Yes.
Your Lordship, I beg to mention item number 5 for the matter become infectious.
Huh?
Matter become infectious.
Infectious. Your name?
R. Shah.
You're not there?
I'm
Why is it infectious? Why is it infectious?
petitioner get the relief. Petitioner get the relief.
It's a case of salary,
Promotion.
promotion. We will take when the matter is there. Okay? As you are not the counsel, your name is not there.
I'm on behalf of P.K. Roy Chaudhary.
Fantastic. Ask Mr. P.K. Roy Chaudhary or you be present when the matter is good. Okay?
Number 1.
I am appearing on the Mrs. P. Dutta. He is coming. Kindly-
Okay, let me hear from what he has to say.
My lord, Mr. Land Senior Mr. Datta also confirmed that his client received yesterday received all the dues, payable dues. I have also filed an affidavit and instruction also have got. My lord, reliefs are paid. I don't know, my lord,
To
whether
forfeit regularize the services of the petitioner during the suspension period.
everything has been given. The regularized payment has been made. All are areas because he retired in 2014.
So you have
All-
regularized it.
Everything has been given, I am told. My lord. I have
Hmm?
filed an affidavit to that effect also.
Show me. Well, let us see what is it prayer. Forfeit regularize the services of the petitioner during the suspension period of so and so to so and to grant on consequential benefit that is increment during the suspension period, an additional increment and selection grade scale which the petitioner is entitled. Now let's see what is your affidavit.
My lord, affidavit, my lord will find. That was filed long back, my lord, 2011.
Hmm?
2011, my lord, I received an instruction. If Lordship may.
Oh.
No, it's not that. Not that. नहीं? कितना है? उसका करेगा? पैसा? पैसा नहीं? Oh, my lord friend is here.
We have to receive all this benefit.
So nothing remains. The learned counsel for the petitioner submits that the petitioner has got all the have all been granted the benefits for which the instant writ petition was filed. And as such, nothing survives in the instant writ petition. Taking into account the above, the instant writ petition stands closed as infructuous.
My lord, I may be excused, my lord. I have a advent mention, my lord. I missed the verse, my lord.
What?
My lord, one advent mention, because my lord, what happened is, your lordship may remember that settlement matter of Porvata district, my lord. I mentioned before your lordship that in typographical mistake is there. Our name is, petitioner's name is not given, and advocate's name also wrongly shown, my lord. And
I have not signed that order till now.
order has been signed, my lord. I have.
Oh, it has got, you have got it.
Now, what happened, my lord, name of the petitioners are not reflected. And second thing is this name of advocate also wrongly typed. So, my lord, that may be corrected, my lord, and
No, you have to file a application for correction.
I have filed application, my lord. That
Okay.
is I mentioning, my lord.
Okay,
And
you want
this
to
is
take
this,
it
my lord,
today?
Your
No,
lordship today
tomorrow.
itself, my lord, to
We'll have it
what
tomorrow.
happened, your lordship given me 30 days time, so time is passing by. That too, my lord.
Ooh, it may not be possible. Tomorrow
Oblige.
for correction, na?
Correction, my.
At number 2 to 3, 2 to 4.
8 is the proper time.
Why? Who is your senior?
He's a second. He's a second.
You start. Tell me what is it?
Lordship, the matter relates to departmental property. After a considerable period of time.
Why are there three writ petitions are here?
2 to 3, 2 and 3.
2 and 3, Lordship.
The 2 and 3. Why? Why there are two writ petitions?
Lordship, the first, the second read petition, that is
4704.
4707/2020 was filed challenging the letter dated 11/1/2010. 11/1/2010, Lordship. That is I-50, Lordship.
Hmm?
Annexer I page 50, Lordship.
Hmm.
The that read petition.
Are you challenging an affidavit in opposition?
No, Lordship. Kindly peruse page 50, Lordship. Annexer I, Lordship.
Annexure I is different. Annexure I is page 44.
No, Lordship, 4626, in 4626.
Again, please.
4626/2011.
Page,
11/01/2020.
page.
Page 50, Lord.
Yes.
That was challenged in the next read petition where petitioner is informed that VRS cannot be given due to pendency of departmental proceeding until same is settled in favor of the petitioner. That is the first read petition. Lordship. And the second read petition, that is the 4626/2011, Lordship. It is it has been filed challenging the decision to reopen the departmental proceeding, Lordship. By letter dated 21/06/2011, Lordship.
May be directed not to proceed any further in the preliminary inquiry department revived against the petitioner by notice dated 21 year. Kindly see where is the notice of 21/6?
Page 52.
Page 52 here, Lordship.
When did you retire? Mister,
Lordship.
when did you retire?
Lordship, he was initially joined on 1981, Lordship. Then
14 lot.
2014, I have retired, Lordship.
So this was divided. Please take notice that the undersigned was appointed as an inquiry officer to inquire into the charges framed against you and conveyed by memorandum of charge dated. The inquiry has to be postponed due to the close of it. Now the inquiry is reopened. You are therefore required to appear before there. But yes, what is there to challenge this?
Lordship, let us go from the beginning, Lordship. Right to what has happened, Lordship, in 1981, petitioner was initially appointed as storeroom manager, and then promoted to the assistant commercial manager of the mill, Lordship. Then on 06/05/1996, Lordship, petitioner was served with a show cause notice, Lordship.
Right. Where is your list of dates? No list of dates.
That time list of death was not asked, Lordship.
Huh?
2011, Lordship, matter.
So? Yes, then tell me.
Then what had happened, Lordship, on 19/09/1996, Lordship, then notice was issued by the inquiry officer conveying the decision for commencing the departmental proceeding. Then what had happened, to petitioner submitted his show cause reply to that show cause notice, Lordship. Then on 2006, Lordship, a revised policy on VRS was introduced, Lordship. It was on 2006, Lordship, and my show cause notice was served on 1996, Lordship. And that revised policy was introduced on 2006, Lordship. Then what had happened in that guidelines for payment of benefits, Lordship, here it has been specifically stated clause saying that VRS should not be given if departmental proceeding is pending. That is after the show cause notice, Lordship. Then what had happened, petitioner received an amount of rupees 1,84,000. Lordship, 1,84,315. As the associated payment That's that.
Yes, Mr. Saikia. Tell me what is the case about?
He, petitioner was the employee of the Assam Fund. It was closed down in the year 1996, the later part of the 1996. Just prior to that, in June, a so-called notice was issued among the grounds that unauthorized absence and some irregularities in while I was discharging my duty in the government. So I have submitted my reply. In the meantime, the mill has been closed down. Though the EP was instituted, date was fixed for holding the inquiry. Nobody turned up except me, and ultimately it has remained in that. Now, in 2006, they have completed a here scheme. And those who qualify on that, as per the criteria that has been laid down under the particular notification, here will be given. Now, accordingly, the here payment has been made
To you.
to me also, but my payment was less.
Huh?
Payment were less. It was not as per the calculation what I ought to have been given. And that remained, ultimately I had to approach this court. And this court directed that I will submit a representation before that they will consider me. Now, that is in 2010. I have submitted my reply. They did not respond. So I have filed the contempt petition. The contempt is also tagged. In the contempt petition, they have first time, they have said I have not been paid because of the subsequent notification by which the notification of 2006 regarding VRS has been modified to the extent that those persons against whom the departmental proceedings are instituted or pending, they will not be given the VRS. But I have already been given by that time. So that particular order,
But you were given less,
I were given,
and
was-
for which you submitted a representation.
submitted a request,
And when the representation was submitted, they did not do, for which you filed a contempt.
contempt.
Now, at the time when the contempt was given,
In
issued,
the affidavit
then they come up with this new notice
notice,
and say that they are reopening it, which
they are
was closed.
reopening. And
So that is what we
has
have
been-
challenged here.
That has been challenged in the first.
On the basis that the earlier departmental proceedings, which was initiated in the year 1995,
96.
and you have submitted your reply as there was nothing done at that point of time. So, and the VRS having been given to you, maybe less,
Yes.
but the VRS having been given to you, they by themselves have done it, and now because of filing of the contempt, they have done it.
Yes.
That is your case.
That is fine. It is
And what is the other one?
the first, the second one, challenging that reopening one and the continuation of the proceeding. in
No, no,
year
no.
2000.
First one is the reopening one. 4626 is the reopen.
Lordship, madam. The-
What is the 4704?
Yes, madam. There, madam, I have challenged that, madam, the VRS has not been given because of that particular clause in the subsequent one. 11/1/2010. That order is under challenge at page 50.
Let us see the prayer out here. So cause why the letter dated 11/1/2000 issued by the respondent number should not be set aside. Where is that 11/1/2010
Page 50,
page
50
of?
of this present one.
No, yeah, I got it. That is annexure J.
Annexure, perhaps it's the I, madam.
No, annexure J of the other one, new
Other
one, the later one. To inform you that on.
Yes,
receipt
J-
your
J of the
letter
other one.
dated on the 12th of February, by letter to- Departmental proceeding was for misappropriation, not for absence.
Absent and some irregularities, not my lord, irregularities.
This
Not-
order
not-
says about misappropriation.
Yes, my lord, it's wrong.
Okay, now what happened to the disciplining proceeding? Then,
My lord, in this, the first one, there's in stay. Pursuant to that letter dated 11/1/2010, they have, my lord, opened the inquiry and they have, but the petitioner was served with a notice dated 21/6/2011 to appear before the inquiry.
that you got stayed.
That been stayed. Because 1996, they have abandoned the whole process. Now, only when I have come this court in 2010, that my VRS after payment of the
Now
VRS
you have been granted the VRS.
VRS has been granted, but payment is less. But what is their contention in the affidavit that I am not entitled to VRS because of a particular?
Now, have you, this is okay, this is okay, this is the second one. But in the first one, where is that notice? You are challenging this 21/6/2011.
11, page 50.
You are challenging this.
Yes.
And this has been stayed. Yes, what to do?
But in this case, also industry is the main, industry and commerce is the main criminal law. They have to rhyme on.
They are not represented, so we will proceed, not represented. What to do?
They have
Now
filed
tell
an
me
affidavit.
what is to be done here? This departmental proceedings is done under what provision?
They have started under the Assam.
Discipline and appeal. Now if it is done under the Assam discipline and appeal rule, can without once the so-called notice or the memorandum of charge has been issued to you, can it die its own death?
Yes, but the conduct of the parties, my lord, is clearly appears, my lord, it has, my lord, the proceeding, this particular proceeding has been abandoned by them.
Let's see the notice. This is your appointment letter. Immediate leave. Device policy.
My lord will find page 54. Pursuant to the, my lord, notice dated 21/6/2011
Now where is the notice
at page 52
of the?
of the first one, 4626 of 2011.
No. I'm not on that. I'm asking you, where is your show cause notice?
My lord, so called notice at that time, my lord, I did not have the, my lord, record, I did not produce, my lord, it is there, my lord, reply I have annexed. This is the so called notice. reopening order is not there, but they have mentioned the affidavit in opposition that they have decided to reopen on 15/6/2000. We hardly getting. We're getting hardly additional. With one component method that is excuse here, that's nothing.
But Mr. Saikia, kindly show me, can a departmental proceeding die its own death?
But in the affidavit, they have said that they, on 15/6/2011, they have decided to reopen. Although the order is not there. Paragraph 8.
No, not reopen it, restart it.
Sure.
Paragraph 8.
Yes, and the minute your lordship will see.
They say that you were a
54.
lot of compelling circumstances for which they were not in a position to do. Now, the question is, can a departmental proceeding die its own death? You are before this court on a presumption that the departmental proceedings must have been dropped and for which you have been given the VRA. And now, when you have found out that the amount which was paid to you was less, for which you have filed a writ petition and thereafter the contempt, they have initiated again, reinitiated the department. That is your case. But the fact that they are saying that the departmental proceedings was never closed. Now, show me something that the departmental proceeding can die its own death without an order by the inquiry, because the inquiry officer was appointed.
He has reopened, therefore, take your logic, page 54. What is the status of the proceeding that is mentioned there at page 54?
Of?
Of the present writ petition.
Yes.
This inquiry dates back to 1996 when I was appointed as inquiry officer to inquire into the charges level against Sri Sumarendra Gogoi, assistant commercial manager.
No. Page 54 is Annexure L.
L. This is the proceeding, madam.
That is what you are referring to.
But-
Yeah, which paragraph?
This proceeding pursuant to the notice dated 21/6.
Annexure L.
Look.
Yeah, the inquiry dates back to 1996.
Look.
Yes.
When I was appointed as inquiry officer to inquire into the charges level against Sumarendra Gogoi, assistant commercial manager, Assam Sponsor Limited, right? So dated 19th September 1996. The preliminary sitting of the inquiry took place on 26/96 at Guwahati, and the second sitting also took place at Guwahati on 14/10/96. A third date was fixed on 28/10/96 for the examination of witnesses on behalf of the prosecution, but it could not proceed further as the Spun Silk Milk Mills Limited was virtually closed down as the mill became unviable. Neither the charge officer nor the management of the mill ever pursued the matter with me during this intervening period. Sri Gogoi is of the opinion that there was no question of his pursuing the matter. With passage of time, the original case record has been misplaced and hence could not be retrieved. However, on a request from the authority, but this authority is also matter to revive the proceeding. This inquiry has been taken up again at the stage where it was abandoned. Xerox copy of the past record have been supplied to me by the management, which enable me to reconstruct the case file. In order to continue with the inquiry, a date was accordingly fixed on 4/7/11, but had to be cancelled as I was laid down with a viral fever for 4 days. Press notices has been issued between 22/7/11 for the inquiry. Accordingly, all are present today. At the outset, the judge officer was asked if he has any reservation regarding reopening of the inquiry after the lapse of little over 14 years. Sri Gogoi has stated that he has virtually forgotten everything and will require to be refreshed with the old documents, including the charge sheet and the connected documents thereof for him to refresh his memory and proceed with the case. Over and above, Sri Gogoi has filed an application stating that he does not remember what took place in those circumstances without seeing the original documents and other files. He has also expressed surprise at the reopening of the case from the side of the inquiry officer without any information from the management of the mill. Mill authority has been requested to formally intimate Sri Gogoi about the decision to proceed with the case. This has never been done. Sri Gogoi has further requested the inquiry officer to allow him to approach the Honorable Guwahati High Court and to seek details thereof. If he is required to reappear for the preliminary inquiry, Sri Gogoi was clearly told that it is not within the competence of the inquiry officer to allow or not to allow him to seek details in any court of law. He is free to approach. So, my lord, this has been closed. So, question of reopening, my lord, has come from my lord as per the instruction of the authority. Now, my lord, who is the authority? Now, here your lordship will find the mill has been closed down. A government officer as a kind of liquidator has been appointed, or in charge of the mill has been appointed, who is basically dealing with all the VRS things. Now, the decision to reopen has to be taken at the level of the mill authority. Or at best, you can say that you can assume that the person who is in charge of the mill, he has to take a decision.
Now, who is in charge of the mill?
Just respondent number 3. At the time of filing of the, that is additional secretary. Industry.
Additional director industry. And the industry is not represented. Now, is it still?
They have filed their application.
No, this was the company, Apple.
Lordship.
Now, what has happened to the company?
Company is closed down. It is only for the liquidation of the assets liability, all this is pending. Otherwise, no contest. But they are also functioning from some other offices. Most probably,
No, so the company still exists.
yes, my lord.
Now, if the company does not exist, then the question does not arise. The question of inquiry does not arise any further.
Because it is closed down, mill has been closed down. No other officials are there except this person as to who is holding in charge of the mill.
No, maybe the assets may not be there. The mill may be there, but whether the company still survives, has it gone for liquidation?
That, my lord, the liquidation process perhaps has not been started. I have, it is not mentioned also in my report. But all the assets liability, whatever, my lord, most of the time has been sold out or this and that.
But the question is,
Yes.
unless the mill has been shut down or the company does not survive, can a departmental proceeding die its own death? Or this court may very well say that no point is served, taking into account that the departmental proceedings was of the year 1996. 25 years have already passed by. It's another aspect of the matter. So as of now. But as on that date was around 11 years, 11 years and another 4 years, 15 years, 14 years was there at that point of time. So there are many judgments that, but can the court quash the departmental proceedings on account of delay?
Yes, that extent of extraordinary delay, the opinion of the department.
But there are many judgments wherein it says that the court cannot quash it. At one point of time, there were certain judgments, but later on it has been changed. Where's the industries department? Call.
It's one of the PV Mahadevan, 1005 6
Hmm?
1005 635. It might be taken for 10, put it 10. But I never
Yes.
There are some other just
In fact, this judgment has been also explained in UP State Sugar Corporation versus Amal Swarup Tandon, reported in 2008 to SEC page 41. Have you got it?
I have 2008 12 SCC
2008 to
Well,
SEC page 41.
230.
Huh?
I am referring to that I did not get, but
Now, in this judgment, it says here it says, strong reliance was placed by the learned counsel for the respondent on PV Mahadevan versus MDTN Housing Board. In that case, there was an inordinate delay of 10 years in initiating the departmental proceedings. Here we are concerned where it has already been initiated against an employee. In absence of convincing explanation by the employer for such inordinate delay, this court held that the proceedings were liable to be quashed in Madhavan. In our opinion, Madhavan does not help the respondent. No rigid, inflexible, or invariable test can be applied as to when the proceedings should be allowed to be continued and when they should be ordered to be dropped. In such cases, there is neither lower limit or upper limit. If on the facts and in the circumstances of the case, the court is satisfied that there was a gross, inordinate, or unexplained delay in initiating the departmental proceedings, and continuation of such proceedings would seriously prejudice the employee and would result in miscarriage of justice, it may quash them. We may, however, hasten to add that it is an exception to the general rule that once the proceedings are initiated, they must be brought to the logical end.
here
It is therefore cannot be laid down as a proposition of law or a rule of universal application. If there is a delay in initiation of a proceeding for a particular period, they must necessarily be quashed. Now this is there. Then you have any other judgments you are referring to?
well, this 2008 12 SCC 230
Wait, 2008.
12 SCC 230.
Yes. You are referring to which paragraph?
Para 17. View of the division bench of the High Court has been applied. Division bench also directed that more than 13 years have passed, therefore not permit the respondent to proceed against the
Para?
17. Only one line.
So far as the grant of back wages is concerned, it depends upon the case to case. But in the present case, as the respondent was found guilty by the cantonment whereby the order was set aside because it suffered from bias, it will be unfair to deny 50% back wages to the respondent. Division has directed that more than 13 years and therefore it did not permit the respondent to proceed against the decided the matter on so and so, and now more than 16 years have elapsed. Therefore, it would not be fair to permit the proceed afresh in the matter. Consequently, we do not find any merit in the appeal. It's okay, but the fact is, once the disciplinary proceedings has been initiated, can it be quashed in the meantime?
But they have abandoned it. They have abandoned it by their very conduct, my lord. Therefore, I have taken your lordship to be minor. They don't have records, they don't have anything. All these things after 14 years, this has.
No, that is a document which has been signed by whom? The reference which you have been, by the enquiry officer. So the enquiry officer has done it. But is it done by the abandoning has to be done by whom? The disciplinary authority. Has the disciplinary authority abandoned it? Yes,
But therefore,
Mr. Kolita.
14 years. they-
Does Apple Fabric survive?
It doesn't survive now.
Huh?
It doesn't survive with
Then what is there?
Lordship.
What remains here in this petition then? Can you now initiate or not initiate? Can you now bring to a logical conclusion the departmental inquiry as of now? 27 years have passed by.
Correct, Lordship. Lordship, actually what has happened is, Lordship, in this case, Lordship, I'm not aware of any of these facts because it's this.
Okay, let me explain to you. Very simple. No, let me explain to you. The person joined sometime in 1981
Correct,
in Apple Fabric.
Lordship.
After that, in 1995-96, in
It was
1996, a show cause notice was issued
Correct.
alleging gross negligence by not on account of not being absent, as well as some allegations of misappropriation has been made.
Correct.
Against that, he submitted his reply
Lordship.
in the year 1996. Enquiry officer was appointed. It was fixed for the purpose of evidence of the management. Till then, it is okay. Thereafter on, there was certain turmoil in Apple, which led to closure. Everything was going on. In 2006, a VRS scheme was introduced. The petitioner applied for that. It is the case of the petitioner that he was paid some amount of 1,82,000. However, the entire amount to which the petitioner is entitled to has not been paid, for which he filed a writ petition. When the writ petition was filed, this court directed that he will submit a representation and for you to consider, the Apple Fabrics to consider. While that application was pending, nothing was done, he filed a contempt. The moment the contempt was filed, notices were issued. They taking recourse to one clause out there in the VRS, that the VRS cannot be granted if there is a departmental proceeding, held that he is not entitled to. And that is one part where he has challenged it. The second is, on the basis thereof, the departmental proceedings which was closed, which nothing was done in the year 1996, was sought to be opened in 2011. Reopened. Now there is a court stay in 2011. We are in 2023. Now tell me what to do. You be the judge now.
It becomes a little bit difficult to say anything on this right now, but as far as Lordship time period is concerned, 1996 it was initiated. Then 2006
It was at the stage of evidence. It was at the stage of management's evidence. Now can you prove it? Those people have all long,
Already-
either there, not there, must have been dead or whatever
Yes,
may be.
yes.
They have tried to reconstruct in the year 2011.
11.
Now we are in 2022. What to do?
I don't think, Lordship, that, I
But
mean,
now the aspect is, can this court quash the departmental proceedings on the ground of the delay which has been caused? We have given an explanation. There was a closure of the mail, there was unrest and everything, for which you could not. Now you have opened. But the fact that you have opened now, strange, because why did you open in 2011? Is it because of the contempt notice being issued? Now, does it show the bona fides on your part?
in my view, Lordship, that's reopening itself. I mean, there is an action and like this shows the conduct. This shows the conduct, like reopening after so many years. I mean, departmental proceedings is a time-bound thing, Lordship. It should be completed within time, otherwise the employee suffers. So now after
No,
reopening,
he has been given the VRS also.
years, but
VRS otherwise could not have been granted as per the scheme if there is a departmental proceeding.
but they have been given to him.
He was given the VRS, but as he did not get the entire amount for
He is
which he filed a writ petition, nothing, and petition was disposed of, directing him to submit a representation. He submitted the representation, and thereupon
Right.
you have, it must have annoyed you.
I'll leave it to you, Lordship.
Oh, no, you know,
I
very easy to leave it.
I have Lordship, I have expressed my opinion, Lordship, because it's a time bound thing, and before they have granted VRS.
If the court ought not to have stayed it, this court in 2011 ought not to have stayed it.
then
Could have said it should be made the subject to outcome of the writ petition or whatever may be.
Lordship.
But having stayed it, then we are another 12 years down the line. What?
At these stays, Lordship, after the only thing is that like stay order was there, so otherwise probably it would have proceeded.
You could have very well proceeded then.
That is one aspect of the matter. That is.
And the consequential thing is the other writ petition where he had challenged the non-granting of the remaining amount. You see affidavit which you have filed.
Lordship, just now I have seen it, Lordship, I could not go through it.
Your affidavit says the reasons why you could not. Kindly see. These are various allegations being made, but the fact that, can you prove it now? Those allegations.
Because like, as far as my information was that company is long time back it's gone and no employees are working there. Only the financial liabilities and small things like that. Some accountant is maybe there who is looking after this, and nothing else. No employees, nothing.
No, there was, you see, kindly come to page, this one is very relevant, page 54 of the writ petition.
Yes, sir. Lordship.
First paragraph on the bottom, on the first paragraph, last 5 lines from the bottom, with passage of time. Have you seen it? First paragraph,
First paragraph, Lordship. Bottom 5 line.
with passage of time,
Which petition, your Lordship? I mean, Lordship is taking which?
page 54 of 4626.
4626, yes. Yes, Lordship, which spaces time the original case record has been misplaced and hence could not be retrieved. However, on request from the authority to revive the proceedings, the inquiry has been taken up again at the stage where it was abandoned. Xerox copies of past records have been supplied to me by the management, which enabled me to reconstruct the case file. In order to continue with the inquiry, a date was accordingly fixed on 4/7/11, but had to be cancelled as I was laid down with viral fever for 4 days.
Now,
no?
this inquiry officer may not have been, would no longer be there, I suppose, because he was appointed in 1996.
Correct.
Huh?
Retired officer.
So that inquiry officer must have gone.
And lordship, like that, lordship, this thing is very important that the case record has been misplaced. There is no case record. They are admitting that, sir. And only the Xerox copies. With Xerox copies, like what kind of evidence and what kind of
Departmental Proceedings Evidence Act does not apply.
correct, correct.
That can be done,
But
but the
it can be
fact
done.
that
But-
these
but
are
we
there,
don't-
but can this inquiry now proceed in the year 2023?
It will be difficult, you know.
Hmm?
It will be difficult to do it at this stage.
Hello. Both the repetitions are taken up for disposal, taking into account the similarity of the facts and the issue, the similarity of the facts and pertaining to the same petition and the parties being the same. From the records of both the petitions, it reveals that the petitioner herein is he alive? Sure.
Yes, sir. The pressure is on me with that body good. He's alive.
Reveals that the petitioner initially was appointed as a senior showroom manager temporarily, where an order dated 31/3/1981 issued by the then managing director of the Assam Spun Silk Mills Limited, for short, APOL. Oh, no. What is that? ASSL, for short. Assam Spun Silk
This is probably not Apollo.
Limited. Assam Spun Silk Milks Limited. For short, the company.
Apollo is some politics. Not
The record further reveals that on 6/5/1996, a memorandum of charge was issued against the petitioner.
Lordship, Lordship, Lordship. I have a small request, Lordship. Lordship, I was assisting Mr. Das in court number 1. Can I be excused, Lordship? He's arguing the matter there.
Very well.
Obliged, Lordship.
Was issued a memorandum of charge. Under Rule 9 of the Assam Services Discipline and Appeal Rules 1964, read with Article 311 of the Constitution, alleging thereby charging the petitioner with negligence of duties, insubordination, inefficiency, and loss of confidential credence. Etc. The petitioner, on receipt of the said show cause, said memorandum of charge, replied to the same
On 7/10/96.
on when
7/10/96.
7?
10/96.
No. Can be. Had replied in the second week of June 1996. And thereupon the petitioner was served with a notice that dated 19/9/1996 by the respondent number 4, who have been appointed as the inquiry officer to hold inquiry on 30/9/1996 at the office of the liaison officer of the Hindustan Paper Corporation. It further reveals from the record that the inquiry officer further advised the petitioner to submit a fresh representation and the petitioner had submitted his reply on 7/10/1996. Upon perusal of the said reply, the inquiry officer proposed to conduct the inquiry proceedings into the allegations and accordingly fixed 28/10/1996 for examination of the management witness. Thereupon, nothing happened in the said inquiry proceedings. Next. It is further relevant to take note of that the state government had issued a notification dated 29/2004, whereby a scheme to meet the situation. No, it is further relevant herein to take note of that the company wherein the petitioner was employed, on account of various strikes, could not function. Under such circumstances, the state government issued a notification dated 29/2004, thereby publishing a scheme to meet the situation like closure of the state of the company. The said scheme was again revised by a subsequent notification dated 15/2/2006, issued to the respondent number 2, another notification was also issued on 15/2/2006 itself, wherein certain guidelines were issued for meeting the basic requirement in the disposal utilization of the assets of the closed state level public enterprise, that is the company. It is relevant to take note of. Where is that VRS in the scheme?
Subsequently, another was issued by notification 15/5/2008 at page 36.
Ah.
Here, first time they have brought in.
When did you apply? When did you apply? Or when did you get the money?
Amount was paid on 15/12/2008, as per the affidavit filed by the company.
26/12/2008, page 7 of the affidavit replied in the other case. Calculation is up to 1/12/97.
It is further relevant to take note of that pursuant to those notifications dated 15/2/2000, those two notifications dated 15/2/2006. Another notification was issued, another office memorandum was issued on 15/5/2008 by the respondent number 2, wherein various guidelines have been issued for payment of the outstanding salary wages, etc., and ex gratia payment to the employee of public center and enterprises released under voluntary retirement scheme VRS under the Asian Development Bank ADB bracket hobo tar pisot dibo AGP RMP. It is relevant to take note of that in clause number 5 of the said office memorandum dated 15/5/2008, it was specifically mentioned that VRS should not be given to those employees workers against whom disciplinary proceedings, prosecution section, court cases, or any other case like suspension, dismissal, etc., is pending settlement. It is the further case of the petitioner that the petitioner duly applied for the VRS. In terms with the notification dated 15/2/2006. It is seen from the records that an amount of rupees 1,84,315 was paid to the petitioner on 15/12/2008. It is the case of the petitioner that the said amount was paid in terms with the VRS scheme announced by the notification dated 15/2/2006, read with the office memorandum dated 15/5/2008. Next. The petitioner, however, was aggrieved by the amount so given, so paid, for which the petitioner filed a writ petition before this court, which was registered and numbered as, where is that?
WPC 47,
Huh?
page 33,
Of
WPC 462.
which was registered and numbered as WPC number 3497/2009. The said writ petition was disposed of by the judgment dated 21/8/2009, no, by an order dated 21/8/2009, wherein this court granted the liberty to the petitioner to file a fresh representation before the respondent authorities, detailing the necessary facts, more particularly the heads under which, according to him, he is entitled to further payment under the VRS. It was further directed that the authority, that if the petitioner files the representation within a period of 2 weeks, the authority would examine the same and pass appropriate orders thereon. And the said period and the said consideration was directed to be made within a period of 1 month from the date of submission of the representation. The petitioner thereupon duly submitted the representation. However, no action was taken by the respondent authorities, for which a contempt proceedings, being contempt case number 28/2010, was initiated against one Mr. Noor Mohammed, the additional director, Industries Department, who was also the in charge managing director of the company. In the meantime, before the said contempt proceedings could be taken up, an order was passed on 11/1/2010, informing the petitioner that the VRS, that the petitioner was not entitled to VRS in view of clause 5 of the office memorandum dated 15/5/2008, as there was a disciplinary proceedings which was initiated against the petitioner was still pending. This communication is the subject matter of challenge in WPC number 4704/2010. Next. It is further relevant to take note of that when the contempt case being CONT contempt case number 28/2010 was taken up on 28/6/2010. It was brought to the notice of the court by the petitioner that the representation of the petitioner has been duly disposed, and accordingly the said contempt proceedings was closed. It further appears from the records that pursuant to the communication dated 11/1/2010, the petitioner was issued a notice by the inquiry officer, that is the respondent number 4, informing inter alia that the inquiry proceedings which was initiated on the basis of the memorandum of charge issued on 6/5/1996 and was postponed due to closure of the mills have been reopened. And the petitioner was thereupon directed to appear before the inquiry officer on 4/7/2011. It further reveals from the records that on 4/7/2011, the respondent number 4 was unwell, for which the matter was again, the inquiry proceedings was taken up on 22/7/2011. Annexure L to the writ petition, that is WPC number 4626/2011, is the minutes of the departmental proceedings held on 22/7/2011. It is the contents of the said minutes, however, is very important for the purpose of the instant case, in as much as the circumstances under which the said departmental proceedings was reopened have been stated. The relevant portion of the said minutes being relevant, being pertinent, is quoted herein below. Page 54 ত আছে, এইখিনি দেই ৰঙা কৰি বাকিখিনি নালাগে। ঠিক আছে। The petitioner thereupon challenged the communication dated 21/6/2011 and the further continuation of the departmental proceedings by filing a writ petition, that is WPC number 4626/2011. This court finds it relevant to take note of that by order dated 14/9/2011, notice of motion was issued and the departmental proceedings which was initiated, which was reopened against the petitioner, was stayed until returnable date. The record further shows that the interim order had been was continued until further orders by an order dated 2/11/2011 and still holds the field. Next. This court further finds it relevant to mention that pursuant to the filing of the writ petition being WPC number 4626/2011. Oh, নালাগে তার আগৰখন 2010 আছিল কলো ন আগতে It further reveals from the records that an affidavit in opposition was filed by the respondent number 3 in WPC number 4626/2011. In the said affidavit in opposition, it has been mentioned that the petitioner was charge sheeted on account of his unauthorized absence from duty and for non-resumption of his duty in spite of various correspondences being issued by the company. Further to that, it was also mentioned that there was gross financial irregularities and mismanagement committed by the petitioner while he was in charge of the company's showroom at Guwahati, as reflected in the report of the Controller and Auditor General of India, for which he was charge sheeted as per the decision of the Board of Directors. Paragraph 7, in paragraph number 7 of the said affidavit in opposition, it is relevant, it was mentioned that the petitioner was never considered for VRS as per clause 5 of the government guidelines dated 15/5/2008, as a departmental proceeding was pending against him. It was stated that an amount of rupees 1,84,315 was paid to the petitioner on 15/12/2008 as salary and other dues till 30/12/1997 on assumption that the leave was available at his credit as on that date without prejudice to the outcome of the departmental proceedings pending against him on the charge of unauthorized absence from duty and financial irregularities. It was further mentioned that the petitioner had gone through the breakup of the bill at the time of signing the undertaking, that he had no further claim in the matter, and on being satisfied, signed the bill and undertaking and drew without any protest. This court further finds relevance to take note of paragraph number 8 of the said affidavit in opposition, wherein it was mentioned, wherein there was an explanation given as to why the departmental proceedings was remained dormant for more than 14 years. It was mentioned that the departmental proceeding was kept pending for many years due to unusual facts and circumstances of the mills. It was mentioned that such pendency was not deliberate, but under compelling circumstances arising out of the precarious financial condition of the mills, which had ultimately resulted in closure of the mills by the government. It was mentioned that the inquiry was restarted as per the direction of the government by letter number ASM.102/81-82-245 dated 15/6/2011. It may be relevant to take, it is also pertinent to note that it is the categorical stand of the respondent authorities that the petitioner have not been given the VRS benefits, as the same was not permissible in view of clause 5 of the office memorandum dated 15/5/2008. Next. To the said affidavit in opposition filed by the respondent number 3, an affidavit in reply was filed by the petitioner. This court finds it relevant to observe that at paragraph number 6 of the said affidavit in reply, which was in reply to paragraph number 7 of the affidavit in opposition, it was only mentioned that the paragraph number 7 of the affidavit in opposition was self-contradictory. It was, however, admitted that the amount received by the petitioner is much less than the amount to be receivable by the petitioner under the voluntary retirement scheme. It was further admitted by the petitioner that he had put the signature purely on bona fide as to the correctness purely on bona fide as to the correctness of the calculations made by the authority, which later on was found to be incorrect. Purely had put inverted comma, put the signature purely on bona fide as to the correctness of the calculations made by the authority, which later on was found to be incorrect. Inverted.
The affidavit in reply of the other, I have given the form, it's under the VRS. Appendix A, notification budget 15/6.
I'm coming in 5 minutes. By the respondent number 3 in WPC number 4707/2010, wherein also it was mentioned that the petitioner was not granted the VRS in view of clause 5 of the office memorandum dated 15/5/2008. Be that as it may, an affidavit in reply was filed by the petitioner, enclosing therein the receipt cum undertaking which was given by the petitioner for receiving the amount of, while receiving the amount of rupees 2,949,000.
This was not given.
Huh?
Alternate calculation was for the next page, 18431. They have again deducted certain amount.
No, this amount, I hear others specify total 2,49,000. No, that is the amount, no?
Ultimately given for the next page.
Crazy.
Page 184, 315. Bottom.
You were only paid 184. Receipt of rupees 2,09,949. And yeah, I had enclosed the receipt come undertake, wherein it has been mentioned that the total entitlement of the petitioner was rupees 2,09,949. And after making of necessary deduction on account of CPF, UPF, UF and others, the petitioner was only entitled to rupees 1,84,315.
This is an appendix A, which is attached to the notification dated 2008. The while granting BRS is formatted.
It is also seen from the receipt come undertaking which was made a part of the affidavit in reply filed by the petitioner on 6th of March 2013. That the VRS was the date of VRS accepted was mentioned as to be effective from 1/12/1997. In the backdrop of the above, this court have duly heard the contentions of the respective counsels. On hearing the learned counsels, two points for determinations arise for consideration. One, whether the disciplinary proceedings which was initiated on the basis of the memorandum of charge dated 6/5/1996 can be allowed to be continued further in view of the fact that almost 27 years have passed by. 23 plus 27. Almost 27 years have passed by since the initiation. Number two, whether the petitioner is entitled to any further amount from the company or the respondent authorities. Let this court first take into consideration the first point for determination. The records the materials on records which have been already discussed about would show that the memorandum of charge was issued on 6/5/1996 and the petitioner had duly replied in the second week of June 1996. Thereupon, an inquiry officer was appointed and the petitioner also participated in the said inquiry proceedings till 1996. The materials on record and the admitted facts shows that there was no decision. That nothing happened in respect to the said inquiry proceeding since the year 1996 till 15/6/2011, when a decision was taken by the government to restart the inquiry proceedings. Pursuant thereto, on 21/6/2011, notice was issued to the petitioner whereupon the petitioner duly participated in the said inquiry proceeding. On 22/7/2011, in the said inquiry proceedings, it was duly noted under what circumstances the said inquiry proceedings was reopened. The relevant portion of the said minutes of the inquiry proceedings dated 22/7/2011 has already been quoted above. Thereupon, the petitioner filed the instant writ petition, and there was a stay to the said departmental proceedings by an order dated 14/9/2011. And the said proceedings and the said interim order still holds the fee.
Lordship, no stay vacation was filed by this.
It was made until further orders.
Stay vacation. No.
It is further relevant to take note of that the respondent authorities, though had filed their affidavit in opposition, but there was no application or any attempt being made for vacating the said interim order so that the departmental proceedings could be continued against the petition. As on today, when the matter is being taken up, almost 27 years have passed by. This court further finds it relevant to take another very relevant, very important, pertinent aspect to the matter. That is, the enclosure to the affidavit in reply filed in WPC number 4704/2010, wherein it has been shown that the petitioner have been permitted to go on VRS with effect from 1/12/1997. The petitioner was also paid the said amount. No, petitioner. The respondent authorities have also acted on the said receipt cum undertaking by paying an amount of rupees 1,84,315. This receipt cum undertaking, therefore, the receipt cum undertaking as well as the respondents having acted upon them and making payment of the amount of rupees 1,84,315 to the petitioner shows that the respondent authorities did not had taken a conscious decision that there was no departmental proceedings which was pending as on 26/12/2008. Or for that matter, on 15/12/2008, when the amount was disbursed to the petitioner. The above will therefore show that though the disciplinary proceedings was initiated in the year 1996, but the respondent authorities have abandoned the said disciplinary proceedings. It was reinitiated when, pursuant to an order being passed by this court, where is that order of Justice Amitabh Roy? Huh? Yes, sir. Pursuant, it was reinitiated. Pursuant to an order passed by this court on 21/8/2009 in WPC number 3497/2009, whereby the petitioner was granted the liberty to submit a representation and with a further direction upon the respondent authorities to consider the representation within a period of 1 month. At that relevant point of time, the communication dated 11/1/2010 was issued, intimating the petitioner that he cannot be granted the VRS in view of the pendency of the departmental proceeding. Although, till then, although at that relevant time, the government even had not taken any decision to restart the departmental proceedings, as could be seen from the affidavit filed by the respondent number 3, wherein it has been mentioned that the government took a decision to restart the departmental proceedings only on 15/6/2011. It further appears from the minutes of the meeting, the relevant portion of which have been already quoted here in above, that the original records have already been misplaced. And there was an attempt being made to reconstruct the said original records with photocopies. During the course of the hearing, this court had put a specific query upon the councils appearing on behalf of the respondents as to whether the respondent number 4 still is in service, taking into account that the instant litigation has been pending for the last 13 years, and he was initially appointed as an inquiry officer in the year 1996. The learned counsels appearing on behalf of the respondent submits that they have no instructions in that regard, but probably the respondent number 4 must have retired. In view of the above circumstances, and taking into account that the departmental proceedings was initiated in the year 1996, and 27 years have passed by, and in the meantime, the BRS of the petitioner has also been deemed to be had been accepted, as could be seen from the receipt from undertaking, and the petitioner being paid the amount of rupees 1,84,000 so and so on 15/12/2008. 18. This court is of the opinion that in the exceptional facts of the case, the further continuation of the departmental proceedings against the petitioner would not be in the interest of justice, and accordingly, the said departmental proceedings so initiated against the petitioner stands set aside and quashed. Next. Now coming to the second point for termination as framed by the court as to whether the petitioner is entitled to any additional amount. This court, by the order dated 21/9/2008, right? 21/8/2009, in WPC number so and so, had directed had given the liberty to the petitioner to submit a representation, and the respondent authorities were accordingly directed to consider the same within 1 month. The respondent authorities, however, have rejected the said representation only on the ground that there was a departmental proceedings pending against the petitioner, which goes against clause 5 of the office memorandum dated 15/5/2008. It is pertinent, it is relevant, as well as pertinent also, to reiterate that as on 11/1/2010, when the communication was issued, when the said impugned communication was issued, there was no decision of the government to restart the departmental proceedings, as could be seen from the affidavit filed by the respondent number 3, wherein it has been specifically mentioned that on 15/6/2011, the decision was taken by the government to restart the departmental proceedings. This court further finds it relevant to take note. Treat it as it may, as the challenge to the said communication dated 11/1/2010 has been pending before this court in WPC number 4704/2010. And the reason for which the impugned communication dated 11/1/2010 was issued, that is, the departmental proceedings, that is pendency of the departmental proceeding, which have been quashed by this court by the directions and observations made here in Supra. This court is of the opinion that interest of justice would be met if the respondent number 3 is directed to take a relook upon a fresh representation to be submitted by the petitioner as regards the entitlement, taking into consideration that as on date, there exists no departmental proceedings against the petitioner. The petitioner is given liberty to submit the representation within 30 days from today. And upon such representation submitted, the respondent number 3 shall consider the same as to whether the petitioner is entitled to any further amount. And if found on verification that the petitioner is entitled to any further amount, the same amount be paid to the petitioner within the said exercise be carried out within 3 months from the date of submission of the representation by the petitioner. The respondent number 3 is further directed to submit a compliance report before the registry of this court upon disposal of the representation. With about the both the restrictions that
Item number 4.
In this case, Lordship, I am suffering, my lord, facing problem, Lordship. I was in Semper, my lord, at that moment, as Chaudhary. I had many advocates, juniors were there, Lordship. I was also there, Lordship. I signed this, Hukalatnama, Lordship. Now, I have no communication with the, my lord, petitioner, neither file it with me, Lordship. I have communicated, my lord, because my name is also, my lord, reflected in the cause list. I just communicated the son of my senior lordship. He also could not find out the file from the sample.
no, but as of now, you have been convicted. Nothing remains in view of this order in the criminal appeal.
Yes.
Then what is wrong?
So on merit, my I cannot submit anything or because I am handicapped without.
No, whatever may be.
Now, in fact.
Nothing remains now. This has been done in view of his previous conviction. And this appeal has also been dismissed.
In fact, after the dismissal order, he has approached the High Court. The single judge has dismissed it. Finally, he has approached the appellate court. So appellate court has given a little relief to the fact that de novo the inquiry has to be conducted in the petitioner on the basis on the materials available on record. And finally, that the inquiry report hasn't come. And and in fact, based on the High Court, that inquiry has been done again afresh. But prior to that, already he has been convicted by the district and session judge with 5 years RI.
No,
So that-
thereupon he has already spent the time.
He has spent the time.
And and Justice Merino
Yes.
while disposing of the year, you did not ask for setting aside.
Yes.
The court said on perusal of the appellants were convicted for 5 years with a fine of 500 in default to imprisonment for another period of 1 month with effect from so and so.
Yes.
The said conviction had expired on 28/2/2010. In that view of the matter, the conviction period of the appellant has already expired and the appellant has become a free man. So that has been happened. But his conviction still
Conviction
remains. And if his conviction remains, then the termination is right.
Termination is good in law.
Hello. Where is the termination?
The final termination is expertly.
Mr. Counsel, whether you appear or don't appear, no problem. This court is going to decide it. Then thereupon, I'm going to decide on merit. Okay. Departmental. proceeding-
Termination is Annex 11, page 92.
In connection with the very go ahead, directed results for a Tino position. We are concerned with 9th of April 2007.
Yeah.
Page 86.
86.
Compliance with the directives of the Honorable Party High Court.
I have certified the, to some extent, lordship. Only my lord case is lordship, the honorable division bench, my lord, directed to my lord, reinstate my lord, the proceeding court. Accordingly, my lord.
Division bench is good,
Second
but,
support notice was issued
but,
for the
but,
person was in
prior
jail.
to
no, but Mr. Counsel, kindly appreciate one thing. His appeal, in the appeal filed by him, the conviction still has been
And
remained.
that cannot be, my lord, denied, lord.
So he
conviction
should
is
have
clear.
challenged on the ground of conviction.
Yes.
But what he did,
On
he
the
said that as he has already passed the period.
He could not submit, my lord, because he was in jail, lord.
Hmm?
My lord, the procedural problem was lordship, he was in jail, my lord, the purpose notice was issued, that is why he could not submit. My lord, reply, lord.
No.
Second support.
Maybe, whatever may be. But if a person has been sentenced,
Lordship.
convicted, then by operation of law, I think some discipline and appeal rules apply.
Yes.
Huh?
Chapter 9,
Some
rule 9.
rule 9A or something.
9.
No, 9 or 10. 10,
Nine,
10.
nine.
No, not 9, 10.
Major penalty. Yes.
No, 10. See rule 10. No, you can't go. আর ওখানে শুনো
Okay, may I hand over mic?
আরে yes. Yeah. You see 10, notwithstanding anything contained in rule 9, where penalty is imposed on the government servant on the ground of conduct which has led to his conviction on a criminal charge.
Yes.
Where the discipline is satisfied for reasons to be recorded, it is not reasonable to follow the procedure. The President may consider the circumstance and pass order, provided the commission shall be consulted as so and so. That's all. And then orders and so appeal against order imposing penalty. এখন কি দিলে? এই পাতলা এখন আছিল। Ah. What is the name of the petitioner?
Ramesh
Ramizuddin. Hmm. And you are suspended from 28 to. You are arrested. Were you not arrested? Arrested. And had arrested the police personnel accused of. But the police, nothing can be done. You are lucky. A rape of a girl. And you're a police. Shame.
I have seen the inquiry report, my lord. There is no, my lord, specific, my lord, statements of the my lord witnesses.
Huh?
The inquiry report, lordship, there is no specific, my
No
lord,
trial.
my lord, statements against the petitioner, my lord. My lord,
Specific judgment in the inquiry of what?
departmental inquiry.
Not necessary.
Departmental not required.
When you have been
Trial.
convicted,
That is a conviction law. No,
the instant petition has been filed challenging the order dated 9/4/2007 passed by the Superintendent of Police Karbi Anglong and the disciplinary authority of the petitioner, whereby the petitioner was dismissed from service with effect from 28/2/2005, semicolon, challenging the appellate order dated 11/3/2010, whereby the appeal filed by the petitioner was dismissed, and seeking a direction that the petitioner be reinstated to his service, granting him all service benefits with effect from 28/2/2005. It reveals from the records that the petitioner, along with, are these two persons or one? How many petitioners?
Two.
Both the petitioners.
Co-accused.
No, here. Both petitioners. No, there is only one. The petitioner, along with one Sri Nipendas, were convicted in Sessions case number 22/1998. By the judgment dated 28/2/2005. For rape of a girl under section 376/34. The petitioner, along with the said Nipendas, were sentenced for imprisonment for a period of 5 years, along with a fine of rupees 500, and in default for simple imprisonment for another 1 month. It appears that pursuant to the said judgment dated 28/2/2005, the impugned order dated 9/4/2007 was passed, whereby, taking into account the decision taking into account the inquiry report, evaluation of the evidence, as well as also the decision of the judgment dated 28/2/2005, the petitioner was dismissed from government service with retrospective effect from 28/2/2005. The petitioner thereupon preferred an appeal, which was also dismissed by an order dated 11/3/2010. This court also finds it relevant to take note of that the petitioner, being aggrieved by the judgment dated 28/2/2005, had preferred a criminal appeal before this court which was registered and numbered as criminal appeal number 83/2005. The appeal was, however, by the time the appeal was taken up, the petitioner had already served the sentence. And a direction was therefore issued to the superintendent district jail Dipu to release the petitioner, as the petitioner had completed his conviction period. Be that as it may, the conviction of the petitioner by judgment dated 28/2/2005 in Sessions Case number 22/1998 remained, and the said conviction was not set aside in the appeal. This court further finds it relevant to take note of Rule 10. Now, the Learned Counsel for the petitioner had submitted that the disciplinary proceedings was not so initiated against the petitioner was not as per the procedure mandated under the Assam Service Bracket Discipline and Appeal Rules 1964. And as such, the dismissal of the petitioner is required to be interfered with. Be that as it may, this court finds it relevant to take note of Rule 10 of the said rules of 1964, wherein it has been mentioned that where a penalty is imposed on a government servant on the ground of conduct which has led to his conviction on a criminal charge, the disciplinary authority can consider the circumstances of the case and pass such orders thereon as it deems fit. In the instant case, the petitioner has been convicted under Section 376/34 for rape of a girl, that too being a police officer. Under such circumstances, even the disciplinary proceedings being initiated by virtue of Rule 10, the petitioner can be terminated, can be dismissed from service. This court also finds it relevant to take note of. The petitioner was a police personnel. And it has been proved beyond reasonable doubt, as could be seen from the judgment dated 28/2/2005 in Sessions Case number 22/1998, that the petitioner had committed, along with another, had committed rape on the girl. The said conduct of the petitioner is unbecoming of a police personnel. And as such, this court, in exercise under Article 2 to 7 of the Constitution, does not find this case as a fit case for interference under Article 2 to 7, under Article 2 to 6 of the Constitution, for which the petition stands dismissed.
Only one lordship,
Cost?
my lord, only one thing lordship. My lord, dismissal with retrospective effect, that is my lord bad in law.
No, it is not. It has been dismissed from the date of the judgment, because that is the date of your conviction. It can't be, you see, I would have understood otherwise. But this judgment, it has been dismissed only from 28/2/2005. That is the date of the judgment, when you have been arrested, you have been brought inside, you have been convicted. At a line like devoted. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, had duly submitted that the dismissal of the petitioner with retrospective effect from 28/2/2005 was not permissible. It could have been only prospective. This court is of the opinion that, taking into account that the judgment of conviction was judgment of conviction of the petitioner in Sessions Case number 22/1998 was passed on 28/2/2005. The dismissal of the petitioner with effect from 28/2/2005 cannot be said to be bad in law. Yes, you want to say it to be infectious?
Lordship,
Infectious?
I have informed the
In
senior
fact,
counsel.
in fact, sir, because he has been promoted, my lord.
Okay. It has been submitted at the bar that the petitioner has already been promoted, and as such, the instant writ petition had become infructuous. Taking into account the above submission, the instant writ petition stands closed as it has become infructuous.
Item number 6 to 19 for admission.
Yes, you have got the reason.
Lordship, I have not received the instruction, lordship. Whatever lordship, last occasion lordship directed me to obtain instruction whether account has been maintained or not in their best of petition. In this best of petition, there is no such order. So, in this present best of petition, there is no such order. So no account has been maintained, lordship. Only that the case of 1101 of 17 was maintained. So I request the authority to give a detailed statement. What amount has been collected on this best of petition. That is not with me, lordship. Due to the concern officer suffering from high flow. So
Typhoid is 18 months.
no, lordship, high flow. The accounts officer. So lordship, I have placed for accommodation for 1 week. I'll provide the details of what amount has been collected, from which commodity, and along with the cash.
Madam, you do also one thing. You get an affidavit being filed as to how much amounts has been collected from your petitioner. They say that no amount has been, they don't have records, because that order was only passed in one writ petition.
Yes, sir.
So for one, they have it, but the others, they don't. So do you have any details on that? Can you find it and file an affidavit as to how much amount? Okay,
I also provided, lordship. I request the authority to.
because
give
you
the
see,
details.
if you have collected
Lordship,
against each of the petitioner,
lordship. So I request the authority to give a detailed statement for each of the petitioner along with the date, commodities, and the form which has been collected, the receipt number.
Because this has happened now from 2009,
No, seven-
2017 on.
2020.
So this is for these 3 years.
Not-
And I think these things must have been computerized.
It is not computer, so I request,
No, every amount after 2017 is computed.
we have the care, form. I request the authority to give the details of a care form,
Hmm.
from which they
Mr.
collect.
NJ Gogoi. Huh? NJ Gogoi,
Lordship.
the Learned Council appearing on behalf of the petitioner, respondent Agricultural Marketing Board submits that he requests for an accommodation for a week so that he can get the details in terms with the order dated 25/7/2008, 23. Please the matter again on is what 31st of August. The petitioner shall also give a detail as to how much amount as per them have been collected by the respondent board
From 2017,
from 2017 on
after GST.
by filing an affidavit.
It should be on
31st.
difficult 30.
Huh?
Can it
He
be
requests for
30?
30.
30.
30. No, 31st. 30 is the
Wait,
work,
this is-
motion day. 31st.
highly on this.
And about 2021.
Ladil Steel. Who is this? Nobody is appearing. What is this matter about? Proceeding under section 9 of the man has been initiated in consent for funding. But
Lordship, my senior is in next in court number 20.
who is your senior?
SCK. SCK.
Where is he?
He is on next in court number 20.
20? Yes, Mr. R.K. Dev Chaudhary. Your name appears in these matters.
20.
Yes, something like that.
Yes.
What are, whether these matters can be adjudicated now in view of the NCLT taking up the matter?
That is what, Lordship, on the last occasion, the counsel
Because
for
the-
the container.
And what is this
Corporation?
2015 matter?
In fact, when the 2015 matter was being dealt with lordship.
Both are same. It
both
is
are
before the
separate.
Ladi
Corrigendum
scheme.
was handed over to the council for the other side. On the basis of the corrigendum, new corrigendum, the other case.
Hmm?
The new case has been filed. There are two cases, one of 15 and one of 20.
Hmm.
When the matter of 2015 was being taken up, in the meantime, a corrigendum was issued by the
Mr. Arkadev Chaudhary, yesterday there was one matter, very
lordship.
important.
I have been informed by.
I have asked them to put your name out there.
I have been informed by the attorney.
The matter pertains to, there was a mini direction to the Ministry of Environment and Forest as regards the Pobichara Sanctuary.
Lordship.
Now, whether there has been a notification issued, because it is the Ministry of Environment and Forest who has to do it. So I have fixed it on 30, I suppose, 30. 38. huh? You just only get your instruction as to whether any notification is happened. Because if whether there was a notification or not, that will depend on whether there is a eco-sensitive zone. Now, the Deputy Commissioner, on the basis of the Supreme Court's order dated 11/12/2018, had observed that there is a eco-sensitive, but their direction categorically says the Ministry of Environmental and Forest to issue a
There
notification,
has to be.
the declaration.
I'll get
So
that.
just find out
I'll
that.
get that.
Yes, now what remains in these matters?
Uh,
They will obviously not be there because of the fact that now it is under the IRP.
That is what,
So if it is under the EIR, all proceedings has to be stayed,
yes,
isn't?
my friend who was appearing for the container corporation, lordship, he was asked to inform the liquidator, lordship, that it is proceeding.
Then what happened?
And then the matter has come up today, lordship.
No, in fact, the date was fixed today.
Yes, so he was supposed to give the information.
Shall place instruction received from the IRP, if any, on the next list. Who is M. Sharma? Mr. Sharma
He is Mr.
had
Nayak.
appointed Vivek Sharma as the interim resolver for the corporate debtor. Now the petitioner can't be represented. MP Sharma,
Yes, yes, lordship.
where is he? MP Sharma, none appears for MP Sharma.
Right.
Wait. This is the order passed. So in view of the IBC conduct, can this court proceed?
I don't think so.
There has to be a freezing. There is no stay,
Here,
no stay.
it's
So if there is no stay, then I think in view of section 7. Limitation. Now, there is an order being passed by the moratorium 14. Subject to the provisions of 2 and 3 on the insolvency man, the adjudicating authority shall by order declare moratorium for prohibiting all or following the institution of suits or continuing or pending suits or proceedings against the corporate debtor, including execution of any judgment so and so, transferring, encumbering any action to foreclose so and so,
lordship,
recovery
he's-
of any property and so on. For the purpose it is clarified that the anything contained in any other law for the timing a license permit so and so. Ended or terminated. Service. Now, I think this order must have stated about the moratorium.
So, lordship, my friend says that the order of the NCLT has
Yes,
It has been stated by-
moratorium has been given.
Lordship, it has been stayed by the appellate authority, Lordship.
Which order?
That order on the last occasion, my senior produced that order,
This order has been stayed.
Lordship.
You are saying about this order of dated 12/7/2023
Yes, Lordship.
has been stayed.
Yes, Lordship. Only after some time I'll give that order, Lordship.
Huh?
I'll give that order by which it was stayed, Lordship.
Then what happens now?
Now, Lordship, as per the IRP, Lordship, the Concord will proceed it with the internal affairs by itself, Lordship. So it has.
So there is no proceeding now.
No.
So where is the petitioner? Counsel? Who got a stay?
We got a stay, Lordship.
Who are you?
I appear for the Concord, Lordship.
Kong?
That's a container corporation.
Corporation of India.
You are who?
In fact, they are not releasing the materials of the petitioner lordship.
Container Corporation of India.
Yes, lordship.
You have got a stay to this order.
Lord.
Insolvency.
Yes.
And what is this matter about? What is the challenge?
Lordship, they put some items, Lordship, from Rourkela to Amingaon, Lordship, and along with them, Lordship, some other consignor were also there. Lordship. And what had happened? In the entire act, there was a misdeclaration. And due to that misdeclaration, the entire act was seized, and differential amount that was 4 times the charge that was levied. So they took a stand that they won't pay that. But, this court, upon consideration of the issue, had directed them to furnish bank guarantee and secure their release of their goods, Lordship. But they did not furnish that bank guarantee.
So you have not released it.
So it was not released.
Now what do you do about those? Are you going for confiscation?
No,
Forfeiture.
since this matter is pending before this court, Lordship, it's lying there in that state itself, Lordship, and it has not moved any.
Then what to do?
We had even filed one iron.
What are the
Lordship.
goods? Goods contains what?
Lordship, with some ferro alloys, Lordship, means iron with that raw material, Lord.
Oh. Then what to do? You rust.
It's trusted, Lord.
This is a matter of 2020.
And one more thing, Lord, yes, 2015 is pending since then.
2015.
Yes.
It's going on.
Yes, Lordship, the one who packed the goods, and it's the consignor, Lordship, who sent it from Rourkela, Lordship. He was made a party in this proceeding, but he did not appear. And one more case was pending in the Odisha High Court. And therein, Lordship, although they sought for a stay or release of the items, therein also, Lordship,
You do one thing. You get that order. You have the order. Stay order.
I have it, Lord.
Okay, 2 o'clock.
Lordship.
Then if the stay is there, we have to proceed then.
Lordship, what has happened is that I am a manufacturer of CMT bars and I get my raw materials from outside. So a consignment, my consignment was sent to me.
Madam, there are 2 matters. One is
Yes,
of 2015 and one is of 2023.
Right, Lordship. It's the same thing because 2020, I'm challenging the provision.
Yeah, then as regards 2015,
But the 2015 also I'm challenging, but 2015 another thing happened. The notification which was there was up to a certain date. So during the course of the hearing, they got hold of another notification which extended the penalty provision further. So that it became necessary to challenge that. So these 2 items are tagged together. So basically, Lordship looks into the notification by which penalty is sought to be imposed on me. Lordship will find there's no provision of hearing, nothing, no hearing, a blanket penalty has been imposed on me, even though I'm not at the wrong. Even because the bars which I had imported the raw materials and my consignor along with me had sent a lots of material for other manufacturers like me. In case of some manufacturers, there was a misdeclaration. As far as my consignment is concerned, as per their investigation also, it's quite clear that there is no misdeclaration and whatever was booked has actually been said. But now by invoking this provision, this circular, what they have done, they have sought to impose a penalty on everyone, all the consignees in the rate, including me. So my point is, I am not liable to pay this. And you have to give a hearing to me. And the first part is that the consigner, the transporter, what he did, he went and moved the Odisha High Court. And Odisha High Court gave an order that you give a bank guarantee and you can take your goods. Now the consigner, on behalf of me, gave that guarantee. I said, I am not bound by that. I'm not a party to those proceedings. And you cannot give a guarantee on my behalf and ask me to pay.
Consigner is him.
No, he's the transporter. So he's the transporter. So in the other case, the 2015 matter, the consigner has been implemented, but apparently consigner doesn't appear ever.
And in this case,
This case, I have not implemented the consigner for the simple reason that these two matters are stacked and I am basically challenging this notification here. And if this notification goes, my entire matter is sorted out.
which is the notification?
Lordship, the impugn notification is the circular is at, Lordship will find the first circular. That one is at page, if your Lordship is looking at the 2020 case, the page is at page 55.
Yes.
Page 55, Lordship will go to page 56, 2.6. In case of misdeclaration is detected in any container, haulage charge on the entire rate shall be levied at 4 times the highest container class rate. This will be in addition to the haulage charge, otherwise levied leviable on the rate. If 5 cases of misdeclarations are detected for a particular CTO, suitable action may be initiated under Article 17 of the concession agreement. So this is what has been done.
No,
And
Madam, what is this haulage charge?
this is the charge which they have for transporting.
Hmm?
For transporting.
Clause 2.1?
Clause 2.1 haulage charge for movement of notified commodities will be levied on the basis of applicable class rate, 15% concession, applicable class rate, 15% concession would be the contract class rate for these commodities until 31/8/2011. Thereafter, container class rate will be applicable class rates minus 10% concession in addition to the rebate of 5% will be admissible on incremental basis for which detailed instruction will follow. So this is what is the haulage charge. Basically for carriage.
Then which has come, this notification you are
Was
challenging.
valid. This notification was valid up to 31/8/2011.
Hmm.
So when they gave us this notification, we said that this validity has gone. So it's thereafter, during the course of the hearing, they came up with another notification, which is at page 108.
Yes, this is of 2014.
2014, which they extended up to 2015. And the Lordship will come to page 109 also.
And when did this incident happen?
2014
14, during this period.
during this period. Now I'm covered. So it has become necessary for me to challenge.
2000.
So this 2020 petition, I'm only repeating myself to the challenge to this notification, because if this goes, the rest goes.
86 is which one?
Lordship,
This one. Kindly come to page 57.
yes, sir. Yes, this was extended up to 30. This is all rate circular 5 of 2011, which was extended from time to time.
So the matter has been reviewed and it has now been decided to revise the list of notified commodity group as per the following.
Yes.
Cement other than white cement, pig iron, bronze iron and slag except scrap materials, iron and steel brass so and so. And here they have removed this pig iron, bronze iron, they have removed it in the revised list.
Lordship, iron and steel has been removed.
No, iron and steel is there.
Cement other than iron, cement other than white cement. Sorry, Lordship, I come under iron. Because they send me ignox.
So iron and steel has been removed from.
No, this revised list is there. This is the existing list. This is the existing list. This is the revised list.
Now, why have you challenged this?
No, Lordship, this I have not challenged. This is the
No. Why have challenged 108?
page 108.
108 you have challenged.
Impune circular I have challenged, Lordship.
108.
Page 108. Because that extends the earlier circular, Lordship. Extends the earlier circular. This extends the validity. Validity of circular number 5 of 2011. Lordship, it's here the last page.
So you have challenged those two, page 55 and 108.
Yes, sir.
So your ground out here is there has been no misdeclaration, which was the subject matter of the other writ petition.
Yes,
And now here they say that when there is a misdeclaration in view of this particular circular of 2011 as well as the 5/5/2014, by which 2011 circular has been extended, then you will be liable to pay 4 times.
4 times, even if the misdeclaration is not by me. It's irrespective of that is how they try to interpret it. Because in my case, there's a lot of people look at the investigation report which have annexed. There's no misdeclaration as far as I am concerned. Misdeclaration was the case of some other persons, manufacturers. Their goods, there was misdeclared. But it came in the same rate. So, at par with them, I have been imposed.
So
this
all these consignments were sent separately,
separate-
but in one rack.
In-
One rack will contain the entire train.
Not the entire train.
Yes, yes. Rack is a train.
Train.
The entire train. So any misdeclaration happens in one boogie also, that will be enough. There will be so many consignments. And your basic ground is that there is no opportunity
Absolutely no opportunity.
of hearing.
Plus, I have been penalized for offense which I have not committed.
That is a subject matter which they will better know
Yeah, because I
as to whether you have committed or not.
but the investigation report
That this
clearly-
court can't look into it, but the fact that there is no avenues available
Yes.
is the question. Yes, yes, you are the main person, Mr. Architect. No, you are the main person. You are your circular.
Lordship,
If we see this circular 2.6 have been
I
put
have
to
seen.
challenge
Lordship.
that if there is a misdeclaration, this misdeclaration has to be understood by each consignment, consignee,
Yes,
consignee or consignor.
Lordship, here, let us understand it this way. Lordship. The consignor sends the goods. Therefore, the declaration has to be
Made by the consignor.
made by the consignor. In this case, the consignor is not the party. The second case.
2014 part.
So yeah, I'm saying the second case. In the
But
second,
don't you think the consignor needs to be made a party here?
Lordship, 2014, I made the consignor party.
But why not here?
Lordship, because I'm challenging this circular,
So what?
the validity of this circular.
But if you want a question of avenue for hearing, isn't it the consignor who has to be heard?
Lordship, because it was that both of them would be tagged together.
So
So Lordship, here, since I'm only challenging this, and this will automatically lead to the disposal of that, the consignor.
just for example, madam, if I dismiss this on the ground that this court can't decide anything on this, then what happens? Because this is a question as to whether misdeclaration was made or not is a disputed question of facts which this court can't decide. Then what happens to this?
Then it goes back to the authorities to decide whether there's been misdeclaration.
But the fact that whether there has been a misdeclaration or not,
That the
who
authority,
who makes the declaration?
the declaration as per the papers given, and when it's booked. We don't know who the consignor is. Here, the consignor was there. Consignor had given,
that is,
No, you don't know the consignor means there has to be a consignor.
there is a consignor.
Who
If
is the
Lordship look in
consignor?
The other rate, 2015, if Lordship takes up first. The consignor is very much there. He has booked it on behalf of the manufacturer of the raw material. Shri Mahapi, Reliable Sponge Private Limited.
Hmm.
So he booked it. And Reliable Sponge booked for many other people also. And he was
The
with
booking will be there with the railway receipt.
the railway receipt.
Where's the railway receipt?
Railway, Lordship, I have an extra railway receipt also. I have annexed all the railway receipts.
Where?
Lordship, in the other case, it's actually, sorry, wait. In the other matter, in 2016 matter, railway
it's there also.
tax invoice, etc. is there. That invoice is there. And page 24, which is
Date
page 24.
of the earlier petition?
This petition only, Lordship, page 24.
Which,
20 on.
which petition? 2020.
2000. Lordship will find series from 19. The invoices are all there.
Page 24.
Yes, sorry, from page 19. Mahabir Ferrois, just a
No,
manufacturer.
no, no. This can't be the railway receipt. If you are sending it, because the problem has arisen because of the railways imposing you. Where's the railway receipt? There we can come to know. This is only an invoice, tax invoice by the
Page
by the
24,
seller.
Let's a minute, 24.
Huh?
Oh, yes, Lordship will come to the old case at page 24, annexure 3 at page 24, container corporation receipt.
24.
Yes,
Page 24 is by whom? This is not a railway receipt.
no, the booking is done by container circulars of railway, but the booking is done by Container Corporation of India as per the instructions of the railway. This haulage charge which they're imposing is as per the circular of the Indian Railway, because they are more like a handling agent, Container Corporation. They handle the transport of goods on behalf of the railways. So this is what they do. Okay, the money received is issued by Container Corporation of India
And the misdeclaration is in respect to what?
in respect of the loading which has been done.
Loading means,
Loading of the containers of my goods.
now is it on the weight or what?
No,
Or misdeclaration would be in respect
of
to?
items.
Okay, so it will be this item or that item.
That
So
item. This item or that item. It's
but these documents at page 24,
yes,
which we are referring to,
yes.
these are money receipts issued by them,
By Amin Khan on taking my booking.
and it has been received from you.
Lordship,
It has been received from you.
yes, I make the payment.
Received from you. This amount has been received from you. Now this declaration has been made. There's nothing mentioned out here in this document that this document, these goods are of this declaration.
Lordship,
Yeah. We will see it from page 27
Lordship
of
will
the
find
earlier
Container
requisition.
Corporation, page 27, Lordship will find.
Mm. The description is iron ignotes.
Yes. These are my receipts of Container Corporation. Everything is there. Consignor, consignee, everything is there. Reliable point is the consignor. Consignee is Dadi Steel. This is what is there. At 27 is there. These are all from Container Corporation of India, who are the handling. If not just look at page, the matter would be clear as to what has happened. At page 70 of my writ, 2020 writ, the plot looked into it.
Yes, Mr. Sharma. You look into the earlier petition, the first one. Kindly come to page 35. They give you the goods to you. The consignor gives the goods to you, makes a declaration. You have given a receipt, which we will find it at page 27, with a description of iron ingots. So that is the declaration as regards the goods.
Lordship. Misdeclaration was detected here, Lordship, in Amin Down, Lordship.
Very well, I'm understood. Because this page 35 has been issued by you for realization of penalty.
Lordship.
And you agree with that penalty.
Lordship. Lordship, may kindly peruse once my affidavit, Lordship, in that matter.
No, understood. Let me first understand. The consignor gives the goods to you
Lordship.
and you take a charge for that.
Yes.
You book it through the rail. You must be having some arrangement with the railways.
Right.
Now, while booking the charge, you give this particular thing at page 27, Annexure 4 series.
Yes, Lordship.
Where you have given the description. Misdeclaration will be declaration of the goods.
That declaration is not here. Lordship.
Huh?
If I just take my Lordship, for paragraph page 70 of the 2020 writ. This is something which has been filed by them in the earlier writ, which would make it very clear, these are the stuffing reports issued by the container corporation. That's the series they have filed. The first one at page 70, Lordship, that will, is for Feroz, PW Feroz. There, what is stuffed is sponge iron. But in case of Ladis, and in case the next also sponge iron belongs to someone else. Then Lordship will come as far as my stuffing reports are concerned at page 75.
No, wait, madam, let me understand it from him. He is the container.
Lordship.
You have given this description of iron ingots at page 27.
Yes, Lordship.
So that is the declaration as regards that is the declaration we are concerned.
Basing upon their report, they have to stop that, Lordship, and after that, Lordship, they.
So you say that they had given you some report and on the basis of which you have mentioned it as iron ingots.
Yes.
Now let's come before that to the invoices at page 21 onwards of the earlier petition.
Yes, Lordship.
Were these documents given to you? 100%. Otherwise, you can't carry. Consignor, consignee. You are the transporter. So this document must have been given. So what is the description of this thing? Ignore
Yes, Lord.
heading 2061090. Down below,
Yes, yes,
description of the
yes,
goods,
Yes, Lord.
page 21. So there it has been mentioned to be
Ignore.
ignored. And this is this iron ignot, you have mentioned it out there. Isn't it?
Yes, Lord.
I think this should be MS ignotes, no? Yes, it is MS ignot. Page 20, if you see. This is MS ignot. So these documents will show this document was given to you. Without this, you can't carry it.
Lordship.
Then why there is a misdeclaration on their part? When you
They-
have
they-
given out here, mention it as the description to be ironic notes.
Lordship, the misdeclaration was found in respect of,
Somebody else?
yes, Lordship.
Then how can they impose, you impose
It is to
upon
be
them?
imposed upon the entire reg lot, entire reg lot,
How?
in terms of the circular. Law.
Let's see that. Then we have to set aside that circular. The circular comes at the behest of here. So you admit to the fact that there was no fault of the petition.
Since the consigner booked it, Lordship,
No, the consigner booked with an invoice.
yes,
You have to carry the invoice. Without the invoice, you can't send these goods to that because otherwise you have a problem with the tax.
Got
The transporter, you are the transporter.
Got
So you will obviously have a consignment note which has been issued by the consignor in favor of the consignee.
while they take delivery, Lordship, then also those goods are there or not, that is to be checked, Lordship, in terms of this invoice, Lordship. And
Whatever
what
may be,
is
that
not.
is why I was looking into the railway receipt because what happens in a railway receipt if you see section 65, wherein it mentions that as regards certain other goods, as regards the weights and all, is it mentioned out there? But here you have taken the responsibility to transport it. You must be having the recs. Now the railways have imposed upon you, and in turn you are imposing upon the petitioner, isn't it? And the railway impose upon everybody. Who is at fault? You must have made some mistake as regards somebody else.
So the delivery was taken in open Lordship, and while checking those Lordship, it was found that it was secret. In terms of the Odisha High Court order, Lordship, the delivery was taken in open Lordship.
Who had taken the delivery?
The other consigners, Lordship.
I'm not concerned with the other
consignor
consignors. I'm concerned with the petitioner.
Not
Now, as regards the petitioner, whether there was a misdeclaration by the petitioner.
it was by the consignor, and they entrusted.
No, the consignor has said to be MS Ignotes. You have mentioned it in your receipt also as MS Ignotes, iron Ignotes. So under such circumstances, where is the misdeclaration by the petitioner or the consignor of the petition?
In respect of Ladi Steel, it may not be there, Lordship.
Huh?
But in respect of Ladi Steel, it may not be there, but there are other consignees, Lordship. If
So we are concerned with other consignees. Other consignees made some mistakes for which the petitioner is also.
that's what the circular says about. Lordship.
No, we'll look into that.
Lord.
But that is the reason why.
Yes, Lord.
That some other consignors made some mistakes in making the description, and you have taken that and have transported it. Now, because of that, the railway, in view of that circular, is imposing upon you the amount, the penalty on account of misdeclaration. In turn, you are imposing upon the petitioner and along with all other consignees. Is that the case?
Yes.
Yes, Mr. R.K. Dev Chaudhary. Now I have understood. Now, what is your relation with this container? What is your relation with him? You allow them to transport.
Yes. To the containers to the railway. Now, if I may just take your lordship to the notification of 2011,
Page 55.
55, and I take your lordship to page 56.
Yes.
Now, lordship, if your lordship will come to 2.5.
Hmm.
The CTOs should declare the details of the commodities loaded in the containers in the forwarding note.
What is CTO?
Container
M.
I'll get. To declare the details of the commodities loaded in the containers in the forwarding note, concerned railway staff should verify the correctness of the commodity details furnished by the CTO at the time of booking. So whatever commodity is coming, that has to be verified. Now comes the next. In case misdeclaration is detected in any container, haulage charge on the entire rake shall be levied at 4 times the highest of the highest container class rate. This will be in addition to the haulage charge otherwise leviable on the rake. If 5 cases of misdeclaration are detected for a particular CTO, suitable action may be initiated under Article 17 of the Concession Agreement. Now, Lordship, this has to be read. It cannot. Here is the case where misdeclaration is like from what has transpired from my learned friend's submission. Some misdeclaration has been made by a party which is not the petitioner. He says petitioner is not. Now, if there is a misdeclaration, Lordship, is 2.6. Lordship, in my humble submission, it has to be read so far as the party who has misdeclared. I do admit this is like it gives a flat meaning, but it has to be read as something who has misdeclared. It will be applicable only to them. It cannot be.
No, there is a reason why I'm asking you. What is your relation with him? Because he has transfloat.
Yes.
Now, who declares? CTOs is who? What is the full form of CTO? The container? What is the full form?
No. No.
Container Corporation of India is different.
No. Lordship, it's different.
Who is the CTO? If I may take your Lordship to page 110 of the Yes.
Of its container
container
terminal operator,
container train operator.
terminal operator, so at the terminal they do, or whatever.
Now, from here, if your Lordship will see, if I may take your Lordship to Roman 2, it appears that is the operator who is sending the material, Lordship. The
So he declares.
he declares.
So if he declares, how can anybody else be made put a
That-
mistake?
That is.
Anybody else? He wants to do whatever that is his lookout. But he has made the declaration. The misdeclaration has been made by him. And therefore the imposition is upon him. Now your terms of the consignment note, which you give, does it contain anything about misdeclaration?
No.
Then how are you imposing upon the petitioner? In fact, it is your liability. The imposition is made by the railways to you, and you knowing it very well. You may otherwise say that they had also to ascertain at the time of booking. Railway. You went all the way to appellate authority to remove this matter. Isn't there a specific order out there that the order which has been passed by this shall not in any manner affect the proceedings in the High Court? It shall be done in accordance with law.
So, uh, here, Lordship, my humble submission, the declaration is made by the consignor. Whoever is sending it.
The consignor makes to him,
Yes, yes,
but he makes to the railways.
Lordship. Under those circumstances, whether the consignee, who is the recipient, that they can be. My humble submission.
So
May not be
therefore, we need not set aside this. We not touch this.
Lordship is not
And
required.
they direct them, you can't impose upon them. I think that is that will help you.
Not to impose upon me.
That
That is the only way. Because you are to make the declaration, you are the CTO. He is not making the declaration to the railways. And in your consignment note, which you issue, the transport receipt, kindly see at page 37 of the new read. Your bill.
you know, if the consignor is responsible, here is the consignee.
Now, kindly see number 4. The consignor must accept responsibility for all particulars furnished in respect of the cargo tendered by him. Okay? For stuffing in the container and carriage by the conqueror. The consignor is deemed to have indemnified the conqueror against any damage or loss suffered by it by reason of incorrect or incomplete particulars furnished by him in this regard. So, are you saying with you are saying that neither the consignor or the consignee in the case of the petitioner's goods have given a misdeclaration? If they have not given, then where is the question of clause 4 coming into your picture? Understood. No, consignor is responsible to you so far as the declaration. But are you saying that the consignor in this case has made the wrong declaration in so far as the petitioner's goods? No. Then how can you attach the liability upon the consignor or the consignee? Very well, but that circular imposes the penalty upon you. It doesn't say to anybody, you give the declaration. The declaration is given by the CTO. CTO is you.
And the CTO is indemnified by the consignor, by the original consignor.
That is why you are the CTO. Chalo, we'll hear it some other day. You get your instruction, any more further instructions? What instruction? That you have wrongly moved the appeal. Huh? Okay, when? 29th. Okay. Matter has been heard at length. List the matter again on 29th
As part of,
as a top of the list for further.
okay.
So therefore, we need not touch on the circular. The circulars are okay.
Actually, Lordship did not.
It's only the
Whatever-
CTO.
Whatever has to be done by the consignor and the CTO.
And the CTO, it's between the CTO and the consignor.
And you are the CTO. You have been most probably penalized.
And
And
that
for
is why,
that, you are imposing upon him. And you know, the consignor would not give you any value. But although, as per that liability, it is the consignor's liability. She is only the consignee. How are you imposing upon him? And have you released the goods?
No.
You have filed any suit for damages? No.
Not as yet, Lordship, I'm waiting for this. I'll file now.
Supplemental is, I don't know, 35 and 36.
it's going into liquidation.
That matter, my lord. Only my lord, yeah, my lord, only my lord, annexure E, my lord, may kindly look into. Annexure E, page 24
Of which writ petition?
of that item, first one, my lord, 2017. On this, that's
Annexure
annexure E, page 24.
E, page 24.
Of those occupants of railway land, they have approached before the principal chief engineer, and principal chief engineer just written to the senior Dan Maligao. Annexure E, page 24.
Yes.
May-
No, understood.
Yes,
That is a different cause of action.
okay, yes, of course, my lord.
For that, I will give you the leave to proceed with them, request
then-
them whatever they may
Yes,
do, and
yes,
they
yes,
shall
yes.
consider.
Then of course. my
But for that, nothing to challenge this public
lord.
domain.
No, in that way, my lord, my matter may be disposed of. That otherwise,
Yes, what do you have to say?
My lord, lordship has seen that this writ petition is against the order of the appellate authority. So, my lord, they have to satisfy your lordship whether
I'm not satisfied.
so the writ petition fails, my lord.
Then
The estate officer which passed the order and the order which was upheld by the appellate authority has become final.
you are having what, business or residential house?
yes, business.
Business.
Rental. Oh, you pay per day, per month, 2,000 rupees
Whom, my lord?
You?
Why, my lord?
till they establish a business in some other place.
My lord, they are unauthorized occupants. my lord.
So what? You have been allowing them to stay.
That is the bonus which they have got from 2014, my lord. And now, my lord, 14 to this period. It is their case also, my lord, that they are occupying.
Yes, Mr. Sinha, there is one judgment of the Supreme Court in your favor. Wait, let me take it out. Yeah, there, got it. The 2000 rupees. I forgot the name of the judge. Hey, continue. Print out. Supreme Court has directed. You want to evict them, pay 2000 rupees per day, per month, for 6 months.
Because in case of unauthorized occupant,
That is what I am saying.
Dr. May, give me the citation. I will also like to go through that judgment.
Print out. They will require rehabilitation. Where will they eat? That was given in 2022. Now we're taking into account the DATA and all these things. We make it 3000.
My lord, basically, my lord, they are against an order of the appellate authority.
That is the same case. This happened in Gujarat. The initiation was done under the Public Premises Act. Matter went to the district judge. District judge then went to Gujarat High Court. Gujarat High Court said that no, all these things has to be, these people have to be thrown out. They have become a menace. Matter goes to Supreme Court. Supreme Court said no. Okay, it can be a big thrown out. But pay 2000 rupees per month to their family, to those people.
To
For
the
6
old people,
to those people who are there for 6
Whether-
months.
whether it will be a
That
precedent
is
or that
2022.
was
We make
decided-
it to
My
3000.
lord, that was the case in that particular case. Whether it become a precedent, lordship will have.
Huh?
Lordship will have it on some other day. I'll also go through that judgment. Whether
Why?
I
You
need to-
have, you have been insisting on taking up the matter. Then,
But basically, my lord, the prayer in the writ petition is that the order of the appellate authority should be set aside. So if your lordship finds that there is nothing wrong in that order,
but I'm exercising 2 to 6. I'm not on 2 to 7.
226, to the extent whether the order of the appellate
If
authority
the
was,
Supreme Court can do under 136, not why can't I under 2 to 6?
they are, it is their own case that they are unauthorized occupant.
Absolutely. These are unauthorized. There's nothing called authorized or unauthorized.
একটা copy মুখ দেখুন।
This is following another judgment. It would look 1997 11 SCC 121. The entity who is the owner of the land, namely Western Railways in this case, as well as the local government and the state government shall be jointly and severely liable to pay a sum of rupees 2000 per month per demolished structure for a period of 6 months from the date of demolition of the structure as ex gratia amount to be the head of the family, public occupant of the concerned or unauthorized structure removed during demolition action. The said amount shall be initially paid by the collector for a period of 6 months only, not beyond 6 months, and shall be later on shared equally by the entity that is the owner of the land, the local government and the state government. Come to number 5, Roman 5. Yes. That was in 2022. We increased it by another 1,000. Isn't it?
Lordship may take up this matter on some other.
No, no,
Let me go through
today.
the judgment, madam.
Today is a Tuesday.
On Thursday, madam.
No, today. And what do you say about 9711 SEC? There also the Supreme Court makes it clear. You have to give them something. So what was wrong in Mr. B. Sinha just asking that I will dismiss it, but however, give him the liberty to approach the authorities and the authorities shall consider. He was only asking that now you have penalized yourself with this 3,000 rupees. This is also public premises. This is also what the Gujarat High Court did. And then the Supreme Court said, no, one can't do like this. आएगी कौन को? आएगी कौन? How many ayat?
2 IS
For which two?
for this writ petition 2017 IAS 47
And
and for other writ petition IAS 41.
2016 is what?
Yes.
Huh?
2017 same other purpose.
And what is 2021?
2021 is the present writ petition.
Huh?
No, 2021 is different writ petition.
That is pending.
It is pending. It's not
Same matter.
same matter.
Okay. Promoter lekho आएगी करो. It we cannot. Pelek order. Both the application, the instant application has been filed for restoration of the writ petition, which was dismissed for default by an order dated 30/8/2022. This court have duly taken note of the contents of the said application, and it was on account of the fault of the counsel who was then representing the petitioners that the writ petition was dismissed for non-prosecution. It is also seen that the petitioner immediately upon coming to learn have thereupon filed the instant application for restoration. Taking into account the above, this court restores the writ petition to the file. I accordingly stands disposed. Now come to it. What do you say? All these are all against the common judgment.
Yes.
10/3/2014.
Yes.
All three writ petitions.
Yes.
Where is the judgment?
It starts from page 66.
Page
66.
Why such a long judgment is required? First and foremost, is it your case that you are the owner of the land?
No.
No. No. You are not.
No.
So you accept that it is a
Yes,
petitioner.
we are
Really?
illegal. Also.
Then what is your right to remain in the land?
Right is there, we are since 1984 we are there. We are continuing our business. We have approached the authorities, and authorities have considered our case.
Hmm.
That some either agreement or license will be given to us to continue our business over that plot of land. Suddenly, this eviction notice has come up, and matter has gone in that.
And there is no stay.
No.
In the appeal, there was a stay, but later on,
But then
But
also
it is
they have
re-
not done
lead
anything.
petition not fair.
That is the bonus which they got, my lord.
Okay, Lekho, all the three writ petitions are taken up together, taking into account that all the three writ petitions arise out of a common judgment. An order dated 10/3/2014
May I
passed by
point
the
out one
learned.
thing, my lord, there are two writ petitions, they have that, there are two missed case for restoration. The third one is not before your lordship. There are three writ petitions filed against the.
One is dismissed for default.
All the three
All the
writ
three are
petitions were
dismissed for
dismissed for default.
One has not been restored.
One had not been listed, madam. Not a single one was restored. Today only your lord restored with the first one.
No, there are two eyes.
Yeah, two IS,
Yes.
actually, there should be three IS.
Which one, where in
It has not been
It's
listed
not
at any
listed,
time.
madam.
no, which matter it has not been restored?
No, all the three are not restored.
The two I have already restored
Yes,
now.
madam. Now just.
Then-
Other one is not in the list. Actually, three writ petitions are filed.
No,
but-
we have three writ petitions here.
Yes, but
Yeah.
the,
Is not.
but the writ
Yeah.
petition
This
filed
is
by,
for IA,
the writ petition 2021 of 14 filed by Bimol Shil.
no, 43 is 2017.
My lord.
Writ petition with 47, miss case 47 is for 2017 writ
17,
petition.
yes.
That has been restored.
Yes, 41 is for 2016.
2017 restored.
2016 is
41 is for
2016.
2016. That has been restored.
The IA of,
2021. Huh?
the IA is not before your lordship.
Let us see whether it has been dismissed for default.
Yes,
Where are you? Why are you saying so? Where is an order of dismissal for default? No order. Why you are saying that it has been dismissed for? आता नहीं यार order को. I don't see any order. 2021 there is no order.
but they have served me a copy.
You have filed it?
But I filed, but the matter is not listed today. madam.
Have you filed it?
Yes, sir, filed. Madam. We have
When?
filed when my lord during May, my lord, in the month of May. Date. Exact date I-
Record of plan. Filing number?
No, I don't have because I did not bring the record, but.
Not necessary. You
There-
don't have. You have a copy.
My lord.
You have a copy.
Yes,
He has a copy.
they have served me a copy.
Filing number? No idea.
No, because record I did not bring.
Because my lord, the 38/2022 order, it reflects all the three writ petitions.
Okay. Two writ petition ना लगा. ये तो writ petition है allow कोई टीम लोगों. 226 one can do. Both the writ petitions. Now, this court proposes to dispose of both the writ petitions by this common judgment and order, taking into account that both the writ petition emanates from a common judgment dated 10/3/2014 passed by the learned additional district judge number 2 Kamrup Metro. In Miss Appeal number 10/2012, and Miss Appeal number 11/2012. The facts involved in the instant cases in both the writ petition are that the petitioners claim to be, the petitioners of both the writ petitions claim to be running their business establishments on their respective plots of land. Being falling under plot number 7, being plot number 5 and plot number 7 of CAT Roman 3, plan number E/5/2012, situated as west side of Guwahati Station under dark number 3189 at Revenue Village West Side Guwahati Station, Moza Jalukbari, Kamrup Metro, Assam. The writ petitioners in both the writ petition claim that they have been carrying on their business establishment for the last 30 years. In the year 2006, the petitioners, along with other similarly situated persons, submitted a representation before the Chief General Manager, Northeast Railway, Frontier Railway, along with all documents for registration of their tenancy and payment of necessary fees before the respondent authority. On the basis of the said representation, the Assistant Divisional Engineer, NF Railway, had issued a communication dated 6/8/2008, 2006, thereby instructing the SSE (W) Guwahati NF Railway to submit a detailed report along with a sketch plan clarifying the details. 1. Roman 1. Whether the plot of land can be spared for license basis. And Roman 2. Whether the land would be required for further development by the railway authorities on the area. Thereupon, it is not known what has happened to the said communication dated 26/8/2008. Be that as it may, on 2/11/2006, the Principal Chief Engineer issued a communication to the Senior DEN, all caps, DEN, Maligaon, that there were some shops over the railway land He further stated in the said communication that some authorized and unauthorized occupation of the land. He further stated in the said communication that notice should be served on all occupants either to remove such unauthorized structures or agree for regularization as per the railway terms, which will enable the railway to get revenue. The senior sectional engineer, Guwahati, had to the said communication dated 6/12, had to the said communication dated 2/11/2006, submitted on 6/12/2006 a sketch map along with the report to the senior DEN Maligaon, stating that the petitioners in both the petitions were occupying railway land for the last 25 years, and that the railway may collect the revenue by giving license to them. It was also mentioned in the said report that the land was not required for further development by the railway authority, as because the state government had already developed the land by making concrete footpath. It was also intimated that 7 numbers of plots, including the plot of petition, of where the petitioners were carrying on the business, the railway may collect license free from the petitioners from their date of occupation. However, nothing further happened, for which the petitioners submitted various representations. Next. It is the further case of the petitioner that a show cause notice was issued on 29/5/2012 under the Public Premises Eviction of Unauthorized Occupants Act 1971 to the petitioner, in terms with Section 4 of the said Act. The Public Premises of 1971 of which cited hereinafter for short referred to as the Act of 1970. The petitioner duly submitted a reply on 12/6/2012, admitting inter alia that the land belongs to the railways. However, submitted that the said land be allowed to be retained by the petitioner on lease basis, by granting license to the petitioner for carrying out his business. The estate officer of the NF Railway on 12/6/2012 itself, after hearing the parties, passed the order under Section 5 of the Act of 1971, thereby directing that the petitioners petitioners are required to be evicted. Being agreed, the petitioners in WPC number 2016/2014 and the petitioner in WPC number 2017/2014 filed 2 appeals before the learned district judge, Kamrup Metro, under Section 9 of the Act of 1971, which were registered as Miss Appeal number 10/2012 and Miss Appeal number 11/2012, respectively. The said appeals thereupon were endorsed to the Court of the Additional District and Session Judge FTC number 1 for disposal.
Number 2.
In the meantime, there were various other appeals which were also filed by various other persons. Which were tagged along with Miss Appeal number 10/2012 as well as Miss Appeal number 11/2012. various two other appeals, various other two other appeals. Right. All these 4 appeals were disposed of by the judgment and order dated
10/3/2014.
10/3/2014, thereby dismissing the appeals. It was further mentioned, it is further relevant to take note of that while dismissing the appeals, the petitioner who were the appellants were also directed to vacate the railway land under their respective possession within the next 30 days from the date of passing of the order. Being agreed by the judgment and order dated, common judgment and order dated 10/3/2014, both the writ petitions have been filed. Next. I've heard the learned counsels for the parties and have perused the materials on record. The fact that the land in question belongs to the NF Railway is not in doubt, as it is an admitted fact, as could be even seen from the replies so submitted by the petitioner before the estate officer. In 96, 97, 11. Under such circumstances, this court finds no infirmity in the orders being passed by the estate officer as well as by the learned court, by the learned additional district judge. The infirmity by the orders dated 12/6/2012 issued by the passed by the estate officer NF Railway against the petitioners, as well as also the order, the common judgment and order dated 10/3/2014 passed by the learned additional district judge FTC Kamrup Metro at Guwahati. Mr. B. Sinha, the learned counsel for the petitioner, however, submitted that there are still certain areas that the petitioners have been doing the business for the last 30 years. And there are various areas which are, and as for the reports which have been also submitted, the reference to which it has reference to which have been made in the writ petition. The concerned respondent authorities, the officials of the respondent railways have themselves admitted that the petitioners can be granted license. He submitted that the petitioners may be given the liberty to submit a representation to the respondent authorities so that they may consider their representation, taking into account that for the more than 30 years the petitioners are in doing their business, carrying out their business establishment, and the entire livelihood of the petitioner as well as the family depends on the said business. This court have given due and anxious consideration to the said matter, and have also perused the materials on record, which also shows that that some of the officials of the respondent railways have recommended that the petitioners and similarly situated persons could be accommodated by giving them the license so that the railways does not lose the revenue. Taking into account the above, this court therefore, without interfering with the order passed by the estate officer, as well as the court of the as well as estate officer dated 12/6/2012, as well as the order dated 10/3/2014 passed by the additional district judge Kamrup Metro FTC 1 Kamrup Metro in Miss Appeal number 10/2012 and 11/Miss Appeal number IMA. Disposes of the instant writ petition, both the writ petition, with the giving the petitioners the liberty to submit representations before the concerned railway, NF Railway, Mr. B. Sinha, the learned counsel, submits for the petitioner submits that the said representation shall be submitted within 15 days from the date of the instant from today. Taking into account the above, this court therefore directs observes and requests the concerned respondent the general manager, concerned the respondent number, the general manager of the Northeast Frontier Railway to consider the representation so submitted by the petitioner compassionately and if permissible and as per the permissible as per the rules as well as the policies of the railway, shall consider the case of the petition. With the above, both the petitions stand. 3,000?
This 3,000 is on a different, my lord, which was a PIL.
What PL? No PL.
Yes,
No
lord,
PL.
that was a PIL, my lord.
No PL. There's to be one case where Hosea, I was about to give this 3,000.
Was allowed. And after DVF judgment, because the notification was put under stay. And on 20th of February 2020, the SLP was allowed in favor of the department. And the notification
Now that 18 days, another order.
Lordship, these are the orders which were special order was allowed on earlier occasion. Lord.
Okay, now for which year they have not got it?
Lordship, because the notification was set aside by the Supreme Court and Supreme Court stayed in 2015 and the SLP was allowed into 2020 law. Reviving the earlier notification. So under notification, the petitioner, they are entitled to a special rate. That was considered and decided on 6/12/2021.
Judgment of 22/4/2010. 20 is which judgment?
Lordship, this BBA proxy,
Where?
is 67,
Page
67.
67. You're referring to which case?
Lordship, this consumer, Godrej consumer.
Yes,
3868.
yes. Page
Page 67, the judgment start,
67.
lot 67, annexure
Oh,
1.
yes, this one. Okay, this judgment was passed on.
Lordship, it was passed on 2020 lot.
Martha.
It was passed on the April 22nd lot, 2020. Page 119.
And what is the direction given?
Lordship, the notification were revived. And
The notifications were held to be good.
no, yes,
The notifications by which they have been the withdrawal of exemption,
yes. It was reduced from 100% to different percentage.
50%.
Yes, but 23% to 58%.
Ah.
That was revived. And in that notification, it is provided that if any industry is entitled to special rate, that is to be considered by the department. So their applications were considered and decided.
Where
on
is it? The direction?
Lordship, no, in judgment that is not there, but in notification it is there. Lordship may come to page 117, paragraph 16.
Page
117,
117.
paragraph 16.
Yes.
Under the circumstances, the respective high court have committed a grave error in causing and setting aside the subsequent notification. Industrial policies impugned before the respective high court on the ground that they are hit by the doctrine of promissory stoppage and that they are retrospective and not retroactive. Consequently, on these appeals are allowed. The impugned judgment and order passed by the respective high courts, which are impugned in the present appeals, quash and setting aside the subsequent notification industrial policies impugned in the respective writ petitions before the respective high courts are hereby quashed and set aside. Consequently, the original writ petition filed by the respective original writ petition before the respective high courts, challenging the respective subsequent notification industrial policy stand dismissed, and the reason stated herein above. The challenge to the respective subsequent notification industrial policy impugned before the respective high court failed. However, it is clarified that the present judgment shall not affect the amount of excise duty already refunded, meaning thereby the cases in which the excise duty is already refunded prior to the subsequent notification industrial policy impugned before the respective high courts are not to be reopened. However, it is further clarified that the pending refund
So
application.
prior to any notifications coming,
that
the impugned notification coming, if any refund was granted, nothing to be.
nothing.
But if it is after that,
Then
the refund applications has to be decided as per the subsequent notice.
notification.
Then what happened?
Here in this case, their applications were pending law for fixing a special rate other than the rate specified in the notice.
Then the petitioner must have moved some application.
Yes, they moved application and that was decided on 6/12/2021.
Where is it?
Lordship, today I received inspection.
Huh?
I didn't get the copy of the order dated 6/12/2021.
Of what?
Allowing them special rate. Their main case was that till the special rate application is decided, because Lordship, what happened during the pendency of the SLP, Supreme Court on 6/12/2015 passed an order,
6/12?
2015, passing an interim order where directed that the industries were entitled to refund of 50% and subject to giving solvent surety. Until then, the judgment.
Where is my judgment of new high tech or what?
Lordship, for that case. Lordship, that was the case where we dismissed their application on the ground of delay. The Lordship has said that because the Supreme Court passed different orders during Corona, so they will get entitled to benefit of that limitation. So their application was liable to be considered on merit. That was the judgment.
Then what, as regards their application, what has happened?
Lordship,
You have considered on merit?
that is being considered. What is the outcome?
No. In this case,
In this case, we have not rejected their application on the ground of delay.
Then
We allow them special rate.
you have not given them the special rate.
We have given them special rate.
Then what is the problem with
Now
them?
nothing become, in my assessment, this has become infructuous.
Yes,
We don't have to copy out that code.
huh?
Because my senior is not there.
They can,
I don't have to fight. I don't even have to fight.
Fantastic. So we'll say that none appears for the petition and dismiss for default. Matter over. Why don't you have the file?
My senior is out today.
So? Then why are you appearing without the file?
Which is the chamber.
What?
The chamber,
Chamber is locked. Are you saying that the chamber is locked? Then
which is out for some medical emergency.
why don't you have the file? I don't understand. What is your prayer? The prayer is very difficult to understand. Writ in the manger should not be issued commanding the respondents to act according to law and not to initiate any act of recovery till the special rate applications have been adjudicated by the respondent number 2 as the same would be contrary to the provisions of Iman so and so. Further read in the nature of AS adjudicate the special rate application. Now you have already decided it.
yes, Lordship, on 6.
Then what is remain? Issued
Nothing remains
restraining
in
the
the
respondent from taking any actions or steps in pursuance to the surety bonds relying on the judgment unless final amount due from the SSC is determined and adjusted to be made or finalized by the respondent on here. Now, have you done that?
Yes, Lordship, we have done.
Then what it means?
Nothing remains.
And where is that order?
Lordship, today I just received information, the second up. I'll produce the order tomorrow. Lordship. 5 orders has been passed in case of the.
In this case,
Yes, Lord.
how many orders?
Total 5 orders has been passed with respect to Godrej Consumer Product. They are having their interest in Kalapahad. They are producing mosquito repellent coils. Lord.
No. So whatever they are saying, that first you need to decide the special rate
Yes.
application.
That is
And you say that the special rate application have been
yes,
decided.
decided. Lord.
So under such circumstances, the writ petition is becoming infructuous.
Infructuous, Lord.
And what about the other matter?
Lordship, item number 23 and 25.
No. This ozone,
Yes, Lordship. This is item 23 and 25. There we have received application. Lordship, there was some technical issues involved in this case, and for a considerable period, the officer was not there in that chair. He had joined last month, so we required 6 weeks time to decide their application. In item 23 and 25.
23 and
25.
so these are questions pertaining to what is the prayer?
Fixation of special rate. Lord. Same prayer in epic. This is item 3002.
Same prayer.
Yes, Lord.
And you have not, as regards ozone, you have not decided.
Yes, that is pending. Lord.
This Godrej you have decided.
Yes, that is been decided.
And ozone you have not.
Yes.
And what else?
One item 24 and about that is we have decided. Have copy of order with me, and it was also provided to my learned friend also on an earlier occasion.
এই আগৰ এই কেছটো গুচাই দেখো এইটো segregate কৰি দিব দেই এইটো বেলেগকে লিষ্ট এইটো ডিসপোজ অফ হৈ আছে তাৰ লগত টেগ হৈ আছে এইটোহে এইটো নাই এইটো হ'ব নোৱাৰে because it has been already dismissed for default so ইয়াত ৰেস্পন্ড নকৰাকে I can't dispose বাহিৰে এইটো মই অৰ্ডাৰে পাইছো because they have not filed in restoration of time. Yes, the other matter is which one?
24 Lord.
Twenty-four to both.
24 Lordship Anna Bond. Cascade Lordship. The prayer for their specialty has been already been allowed. Last page.
So you have already done at 44%.
Yes, sir.
এই দুখন গোটাই দিম।
So 23 and 25, we may be allowed 6 weeks time to.
What are the impugned notices here? 1/1/2021 and 22/4/2021.
We issued notice for asking for refund of the amount which was paid as per the Supreme Court order.
1/1/2000 demand and recovery of So these will be now subject to outcome of this.
Yes, fixing of a special rate.
Huh?
Fixing of a special rate.
So this will be subject to this order of 19/9/2020.
Yes, sir.
Huh?
Yes.
So you will be considering these two. So obviously then these two orders will be bad.
Yes, sir. This demand notice will go. Lord.
So these demand notice be set aside.
Yes, sir.
That now with this fixation of bread,
That will follow. Lord. If,
it has to be
if
done in accordance with.
yes, yes, sir.
Madam, how many years of practice? 2 years. 2 years. Fantastic. You have been with the same chamber? Now you must be understanding it. There are 2 demand notices issued pursuant to the VVF judge. Okay. Now those 2 demand notices you have challenged on the ground that they have not fixed the special rate. Okay. Now, while an order date in 19/9/2022, they have fixed the special rate at 41% of so and so. Rightly, wrongly, whatever may be. That's another thing, which this court at present cannot look into. And the demand notices which were issued at that point of time was without the special rate being taken into consideration. So under such circumstances, those 2 demand notices are to be set aside. And this in view of the special rate having already been fixed. Okay. The other 2 matters, we will have it when? When is your senior available? 30th. We'll have it on 31st. देखो. The instant writ petition has been filed by the petitioner. Challenging the notices dated 1/1/2021 and 22/4/2021. As well as for a direction upon the respondent number 2 to adjudicate the special rate application strictly on merits. This court have perused the notices dated 1/1/2021 and where's the other one? (22/4/2021) is where? Ah, 22. As well as the notice dated 22/4/2021. In terms with the notice dated 1/1/2021, the petitioner was directed to pay back the refund sanctioned to the petitioner of an amount of rupees 6,47,530. In the subsequent notice for demand dated 22/4/2021, it was mentioned that it appears that the said notice of demand, said demand and recovery notice dated 22/4/2021 was issued without taking into issued at a time when the petitioner was yet to file an application seeking fixation of special rate. It reveals from the record, no, please stop. Mr. S.C. Kyle, the learned counsel appearing on behalf of the GST department, had submitted that on 1/3/2021, the petitioner had submitted an application for special rate pursuant to the said application so filed by an order dated 19/9/2022. The principal commissioner, CGST Commissionerate Guwahati, had, in terms with para 3(2) of the notification number 20/2007-CE dated 25/4/2007, as amended, fixed special rate representing actual value addition for the goods falling under Chapter 32 of the first schedule to the Central Excise Tariff Act 1985, manufactured and cleared by the petitioner during 2017 and 18 at 44.70%. In view of the subsequent event of fixation of the special rate by order dated 19/9/2022 and the notices, the impugned notices of demand dated 1/3/2021 and 22/4/2021. 22/4, na?
Yes, sir. 22/4/2021. Page 267.
Cannot exist. Accordingly, the impugned notices dated 1/3/2021 as well as dated 1/3/2021 and 22/4/2021 are set aside and quashed. Thereby giving the liberty to the respondent authorities to take such steps as necessary in terms with the order dated 19/9/2022, whereby the special rate has been fixed for the year 2017 and 18 at 44.70%. With the above observations and directions, the instant with petition stands disposed. The copy of the order so submitted by Mr. S. C. Kyle is kept on record and marked with the letter X.
Had a small request, liberty may be granted for question of imposition of interest.
Huh?
For the interest part, liberty,
I don't get you.
lordship, for the interest part, liberty may be granted to approach.
The area, last line to liberty to liberty is granted to the. Now, however, liberty is granted to both the petitioner and the respondent to take appropriate steps in terms with the order dated 19/2/2022. Huh? Pending applications, if any, stands with.
Another item 27 and 28. Is that also relating to special rate that has been decided? Actually, not written.
What is this part under 3(1) of the notification is what? Delay.
That I have to upload. For 14 and 15, their prayer was rejected. Lord. Another for
Why?
that lordship, I have to obtain order.
No, it is given out there. Now, what is it? 27/20.
27 and 20.
RT plus poly. Duita hai RT poly plus.
Yes, sir. One, unit 1 and another unit 2. There
There
are
are
two
two
units.
cases.
Which one is both are behaving?
My lord,
Both are related.
This is 2008-9 to 9-10
Yes, sir.
and 9-10 to Iman.
It's their application. Two 2008, 9, 10. Page 177.
Hmm?
Page 177.
Where is the notification? Here, T1.
Not-
T1 is, what is this 3-1?
I'm-
You have rejected
14, 14.
You have rejected 14-15 being rejected, being barred by para 3(1) of the notification dated 20/Iman dated Iman as amended by notification dated Iman. What is 3(1)?
my lord, para P1
Goods falling under chapter
Notification.
24.
That's not typical.
P1. P1.
Page 59, page 59 start. Notification 2007.
Good. I've understood that, but what is this 3-1 business?
P1, my lord, page 62. At page 62 is reflected the para 1.
What is your prayer?
Notwithstanding anything contained in
To
para
act
2A.
according to law, read in the mention so and so. So this is a copy paste petition.
Actually,
It's a copy paste petition of with others. Who has copied who? Isn't it, Mr. Sahu?
Hello?
Isn't this a copy paste petition?
actually, no.
Absolutely. You see the other petitions which I've read, exactly the same word,
Actually,
Even-
matter is
even
same.
the semicolon is the same.
My lord,
Who has copied whose?
my lord, this matter is same, notification is the same, and everything is same. So
No, my only query is who has copied whose? That is why there is no mention what is it. What do you want here?
My lord, here in this case,
You want that till the special rate is not fixed.
Yes.
Nothing to be done. No, the special rate has been fixed.
no, my lord, I have not received any copy, any order, nothing.
An order is passed on
1 hour-
18/8/2022.
1 hour before.
You produced that order
I'll produce. Yes.
on, when did I fix that? 31st, na? 31st, Itu.
1 hour before I confirm from the petitioner.
You get these orders, huh?
Yes, I open all the order.
List this matter again on 31st. Who copy paste who?
My lord,
Huh?
actually, I have prepared this.
What
I-
actually?
I think, it's secret law.
The amount of difficulty I had with your the other not new tech or Northeast high tech or whatever. 31st kolo. Hey, agor method. Agor duta 23, 24, 22, 23. You get the list the matter on 31/8/2023 on which state Mr. S.C. Kyle shall produce the orders as in respect to the petitioner hearing regarding fixation of the special rate.
Now item 29. Also special rate in order has been passed.
Rate passed.
Like 24 lordship.
Purpose of the order produced by my current counsel, the case may be disposed of by setting aside the demand notice and show cause notice and with the direction to them to recompute in accordance with the fresh order.
Where is it?
But lordship, for one particular year, my application for special rate has been rejected. I see in the order, so liberty may be there.
Which rate?
Lordship, the last page, last but one they allow, last page they reject. On the below mentioned part, order.
I fixed the special rate of the demand for 2,052% for 9/10 and 10/11, 55 for 11/12, 64 for 12/13, 49 for 13/14, 52 for 15/17, 47 for demand as per so. I reject the claim of so and so for fixation of year being barred by para 3-1 of the notification as amended. What is this 3-1?
Perhaps they are talking about time bar lordship. In P1 it specifies that the applications have to be filed before 30th of September each year. But since the Supreme Court cases were pending till 22nd of April 2022.
No, that I have already taken
that
care
has
of
been-
in my
that has been
other
addressed in
urges.
Northeast High Tech lordship.
Ah.
But though it has been mentioned as being rejected due to time bar, but it has not been discussed in the order. So I also need to find out lordship. That's why I am asking
Now
for legal.
3-1 is where? Show me. He could not show it to me. What is this 3-1 business?
Lordship, P1 will be a page number.
Yeah, the petition is different.
Page 27.
Page
26, lordship, 26.
P1 is at page.
26 is the notification lordship. Page 3-1 will be at page 27.
Understood, but where is this 3 Roman 1?
It
is
is not
there.
Roman, it will be 3-1 Lordship.
3-1.
Oh, but here it has been mentioned as
Might have
3
been
1
wrongly
Roman 1.
It
Nothing so and so
It talks about,
shall have the option not to avail the rates of so and so. Whatever the mandatory. So this is for time.
Lordship.
this is for time.
They mention also that it is barred, but they don't discuss it in the order, so liberty is Lordship. I read through the entire order, I could not find any discussion.
The instant writ petition has been filed. Challenging the order in original dated 5/11/2021, as well as for setting aside the show cause notice dated 20/11/2020. The petitioner also seeks for a direction upon the respondents to decide the applications for fixation of special rate filed by the petitioner before initiating any process for recovery from the petitioner as per law. Where are those things? The original order?
Will be page 95 is the order, sorry, Lordship, page 81 is the order. And page 40 is the show cause. Page 93 is the operational part.
Here, this was without taking into account the special rate.
Lordship.
And this is for which year?
This order, Lordship, it all the years all together, club together.
Hmm?
All the years club together, Lordship. Lordship will
How do you know?
it-
This order is of 5/11/2021.
Lordship,
This
page
is pursuant to
85
the show cause.
Yes, Lord.
Pursuant to the show cause.
Lord. Page 85 contains the details of the period.
Page 85.
Lordship, the table is,
Now show me the show cause.
the show cause will be page 40, Lordship.
40.
Details that.
It
says
will
42.
लिखे लिखो, it will लिखे. I have, this court have duly taken note of the demand cum show cause notice dated 20/11/2020. From a perusal of the said show cause notice, it reveals that for the period from December 2009 to October 2015, as well as for November 2015 to June 2017, an amount of rupees 1,52,55,181 was sanctioned, was disbursed pursuant to the interim orders passed by this court dated 9/12/2016. And the petitioner herein had also submitted a surety bond oblique the solvency certificate to the Jurisdictional Commissioner of Central Excise and Service Tax, Dibrugarh. It further reveals from the said show cause notice that the petitioner was directed to show cause as to why the said amount of refund of rupees 1,52,55,181, as well as the interest and penalty should not be imposed upon the petitioner. The petitioner thereupon submitted a so-called reply stating the grounds as to why the petitioner should not be made liable. Stating the grounds why the petitioner is not liable. Thereupon, an order was passed on 5/11/2021, whereby the Assistant Commissioner of the Central Excise Central CGS GST Division Tinsukia have imposed the demand of rupees 1,52,55,181 and had also confirmed the interest at the appropriate rate as per section 11AA of the Central Excise Act 1955. However, no penalty was imposed. The petitioner thereupon filed the instant writ petition challenging the show cause notice as well as the impugned order dated show cause notice dated 20/11/2020 as well as the order dated 5/11/2021. It is also seen that the petitioner had also submitted application requesting for fixation of the special rate for the various years for which the show cause notice as well as the order, impugned order, show cause notice dated 20/11/2020 as well as the impugned order dated 5/11/2021 was passed. The learned counsel, Mr. S.C. Kyle, appearing on behalf of this court finds it relevant to take note of that by an order dated 10/11 to 10/12/2021, this court issued notice and granted some interim protection to the petitioner. Today, when the matter was taken up, Mr. S.C. Kyle, the learned counsel appearing on behalf of the GST department, have produced an order dated 18/8/2022, passed by the Principal Commissioner, Central GST and Central Excise, Commissioner Dibrugarh. A perusal of the said order reveals that the petitioner have been granted the special rate at the rate of 52% for the year, for the financial year 2009-10 and 2010-11, 55% for financial year 2011-12, 64% for financial year 2012-13, 49% for financial year 2013-14, 52% for financial year 2016-17, and 47% for the financial year 2017-18. However, by the said order dated 18/8/2022, the petitioner's claim in respect to fixation of special rate representing the actual value addition for the financial year 2014-15 was rejected, being barred by para 3 Roman 1 of the notification number 20/2007, the CE dated 25/4/2007. Taking into account that special rates have already been fixed, and accordingly, the impugned notice dated 20/11/2020, as well as the consequential order dated 5/11/2021 cannot exist in view of the special rate having been fixed by the order dated 18/8/2022, for which the impugned notice dated 20/11/2020, as well as the impugned order in original dated 5/11/2021 are set aside and quashed. In that view of the matter, this court, therefore, it is further observed that setting aside and quashing of the order's impugned notice dated 20/11/2020 and the order dated 5/11/2021 shall not preclude both the petitioner and respondents to take appropriate steps on the basis of the impugned order date, on the basis of the order dated 18/8/2022. 18/8/2022 passed by the Principal Commissioner, Central CGST and Central Excise Commissioner at Dibrugarh. Full stop. This court further finds it relevant to take note of another submission of Mr. D. Saraf, the learned counsel appearing on behalf of the petitioner, wherein he submits that by the order dated 18/8/2022 passed by the Principal Commissioner, the petitioner's application for special rate for the year 2014-15 have been rejected without assigning any reasons. Be that as it may, it being a separate cause of action, the petitioner is at liberty to challenge the same if so advised. The order dated 18/8/2022, so produced by Mr. S.C. Kyle, is kept on record and marked with the letter X.
Much.
Yes, Mr. Chaudhary, that matter? Yes, yes. Others may go. Your matter, I'll finish it.
Item 26.
Which one?
Item 30,
What is that matter?
regarding electrification date compensation matter. It was heard by lordship last week and it was fixed as a part third matter.
Is it parted?
Yes.
Parted demand daily ka mata na je?
So my lord, it may be taken up on next Tuesday or Thursday matter.
You are what?
I am for the, I am
ACB,
for the,
APDCL.
this is mother. I am for respond number 2.
And he?
He is for APDSL.
Oh,
Restriction
that
filed by
one.
APDSL.
Oh, I asked you to pay more money.
No, your lordship had asked me to.
No. I asked you, I remember asking you to pay, why not 4 lakhs? The 4 lakhs was, this was, you say that this person did
5
not
lakhs
have the
was given,
authority.
Yes, the quorum.
The quorum was not
Yes,
there, but you were otherwise liable to pay 4 lakhs.
Yes,
If they-
sir.
So then why you are not paying that?
No, your lordship, that, what this order, this entitlement to 4 lakhs under the scheme, your lordship, you can entitle.
Understood, but Why are you fighting unnecessarily? The order which has been passed by them also is 4 lakhs.
No, it's 5 lakh. 5 lakh.
5 lakh.
Okay, well, now make it 4 lakhs.
Very well, if that is.
Interest manner with
Yes,
interest
we
is
have
there.
al-
Malak.
we have al-
You see, there how much interest was given?
we
6
have-
lakhs, sorry, 6% matter.
6%.
Yes.
Now here how much as per yours?
Yes, there is the, some,
As per your memorandum, how much from the date of the incident?
yes, we have already paid we have already paid certain amount to them. So around just 1.5 lakhs is left, your lordship. We'll pay it as, along with whatever interest is calculated. Very
What
well.
is this unnecessarily fighting with this thing? I think APDCL has better things to do.
Okay,
Fight
lordship.
with more vigor and energy in respect of
Petition
other
was
matters.
filed before my time, but I have to at least see it to the end, your lordship.
Does it mean that then also you are a state authority, you have
And
to
the
be
only
more
thing
clear.
that order was arbitrarily passed by the passed under the signature of the chairman. in
Without the
TLSA.
voting there.
But I think that as per my information, it was heard by 2 other members also. But their signatures
Whatever
are
may
not
be, Mr.
there.
Let us not go into all these
Yes, sir.
details.
Okay.
He has to pay. How much you have to pay for
We
that?
have already paid 2.5 lakhs. We have to pay 1.5 lakhs more, along with the applicable interest, whatever. it-
How much you
I
find
do
out
not have the
and
exact.
you pay.
Yes, we'll do it.
We will take up this matter again on 19th of September.
Very well, yes.
In the meantime, apprise this court how much you have paid.
Very well.
Let the matter be listed again on 19th of September, on which date Mr. KP Pathak, the learned counsel appearing on behalf of the APDCL, says apprise this court as to whether the entire amount as per the order passed by as to whether the petitioner shall apprise this court of to do one thing. Four lakhs is the total amount plus interest, which is to be paid from the date of the incident.
Yes.
And what is the interest as per your memorandum?
As per the memorandum, from the date 12% from the date of date it becomes due.
So from there to how much it is, you have paid till now 2.5 lakhs.
2.5.
And remaining is how much?
1.5. Plus
1.5 lakhs plus
1.5 plus
12% from the date of
plus-
the year. How much?
I do not have the exact figure.
Do it in the computer, mobile, and finish it off and give it to me.
Very well.
Then I'll pass the order that you pay that on such and such, then we'll take it up.
Very
This,
uh,
we
Partner-
let us not go into the nitty gritties of what order that has.
Okay.
Malak,
5
that
lakhs
matter
plus-
remain part-time.
Not to dispose today.
But,
He has only to give me the calculation. Yesterday I was taking up one matter of the S. Dotto and the other one was Mr. R.K. Talukdar. That was a matter as to how the apportionment has to be done in respect to a Lok Adalat order. Oh, Mr. Dotto knew how it is to be done, but he was the sufferer, not the beneficiary. So he was not inclined to do the calculation. Mr. R.K. Talukdar was not there. He is not doing the calculation. So yesterday in the evening, I had the only business to do that. And it took me more time. And I could not correct many orders because of that. So you do that
I'll
calculation.
make the calculation.
It's a simple thing. You just minus it nowadays in the, what you call the
Yes.
mobile, you can get it
Very
done.
well.
Find it.
Milord, I'm sorry, Milord, I'm making a mention for item 34. It is said that BTC Boruland Territorial Council election matter, my lord, has taken up. Lord, some instruction was called for. Lord, can it be fixed on the, Milord, day after tomorrow? or next week? Okay.
Let it be on 29th. No, not 29. This will go on sometime around 7th of September.
Just one. What we have got for inspection, there is a gazette notification.
For what?
Not for declaring the results, Malak. But the issue was raised on last occasion, but where the. They can brought the same on record. Other issues are also there.
You bring this by way of. Yes, Mr. Ko.
Item number 32, that AIDC part matter company secretary, they also paucity of time.
No, I am taking up that other matter.
Yes,
That needs to be
May I pay for a date as per your lordship's convenience?
convenient. With this convenience business, it is going to have to be on a Saturday, huh?
And let it be on 12th of September.
12th of September.
Development. Habits have become.
No, thinking about your matter out there and then getting the thing done out there to the effect that you had taken the pain of fixing the marriage. And after the fixing of the marriage, you have not been able to take the legal problems in spite of being a senior counsel. So that is the reason. Yes, Mr. Chaudhary, your matter.
My lord, item number 24, my friend and Mr. my lord, let us say 6 on 7. Let it be on the second week, my lord.
Which one?
Item 24, my lord. My friend,
54. It is on, when do you want?
my lord, let it be on second week, my lord. Let it be on 12th of September.
Second week is on, second week is on 7th, is second week.
No, but 12th of, no, 7th on second week.
Why do you need it?
My lord,
7. I fix it on 7.
my lord, that date, let it be on 12th.
Who?
That particular item number 20.
Why? There's some good reason for that.
Not because there is it is in the governor is represented by the AG. He will not be there on that particular day.
First, let me hear him.
My lord, then it's
You may say that you may not require the AG. As on that date, the AG was not required. I had only asked him to bring on record that notification. Thereafter, we'll look into it.
that notification is there.
So 7th is there.
May we bring it on record? That gazette.
I told you, you'll bring it.
Election Commission.
Bring that notification. Let the matter be listed. 8/34. Let the matter be listed on 7th of September 2023.
Right.
Mr. Ardupe, the Learned Counsel, appearing on behalf of the Assam State Election Commission, submits that he has got the gazetted notification. This court deems it proper that the said being an issue involved in the instant proceedings, the same should be brought on record by filing an additional affidavit. The affidavit be filed by 1st of September.
Okay.
Yes, Mr. Chaudhary.
26.
Yes, what is the age of your people?
I received some instruction, but there are some documents also regarding submission of NOC, my lord, in the affidavit, my. That also furnished me yesterday, my lord, by the son. They have 2 sons and 2 daughters, my.
No. First and foremost,
My lord.
you say that it belonged to your husband.
Lordship.
You are 56 years old.
Lordship.
So meaning thereby, you have your son and your daughter.
Lordship.
Then the son gets, your right is only 1/8.
My lord.
Then if your right is only 1/8, how can you claim the ownership without the main person being the owner?
My lord.
What is wrong with them?
According to the instruction I received, my lord, apart from the my lord applicant here, my lord, he has 2 sons and 2 daughters.
Then,
2 sons and 2 daughters.
so furthermore,
No, my lord.
no,
then-
whatever may be, your constant rate is 1.8.
Yes, that I understood, my lord.
So
But
your rate
according to
is,
them, my lord, we have
your
to-
percentage of the property is 1.8.
Yes.
So the others may very well tomorrow say they know.
That is why, my lord, they have to furnish an NOC.
Who?
Other co-sharers also who are
Yeah.
yes, my. As per their guidelines, my.
You have not,
No, my lord, 2 sons have furnished the affidavit, my,
where?
to the IOC, my.
You have given?
Yes, my lord, whatever documents I have received yesterday,
No. Have you submitted?
according to my instruction, they have submitted.
No. Mr. Chaudhary, is there any affidavit filed by the sons?
I have asked for the, my lord, complete application. And that does not contain, my lord, these documents. No,
But I have.
and that
copy
has
of
not
the
been
affidavit.
stated in the application form also. Application form is annexed.
From where can you get the records?
18/12/2019, my 18 affidavit, 2 affidavit.
You see, the matter has been heard.
Yes.
Only that is there. If there is no affidavits out there, he has no case. But if there is some affidavits thereby giving their consent out there, that will be in terms with your policy.
Yes,
So then he can be brought within the lot 1.
Yes.
lot 2 and lot 3.
I have furnished copies of two.
No, no, no.
That's why I'm
Why
saying.
you have not enclosed them at the
That's
time of
why I'm
filing of the
saying.
report? Okay, when can you get it? Will you dispose it of?
Day after tomorrow, Mother. Tomorrow I'll get it.
Tomorrow is what date? Tomorrow is, okay, let's have it on 24th.
Fine.
List the matter on 24th. Because liberty is given to the parties to mention the matter for upgrading.
Okay.
In fact, what happened, Mr. Chaudhary, that matter I was saying. Here, most of the councils who have done these matters pertaining to that Lok Adalat, not Lok Adalat, the insurance, they actually don't know how the apportionment happens.
Yes, yes.
And without knowing it, they keep on filing. Neither at the time of the passing of the order of 50%, there is an order being passed. I sometimes think why I should, then I think why should I? It will make it further more complicated. Because what happens if you don't pass an order, the amount will be first apportioned towards the interest, then towards the cost, and then towards the principal. Now, what has happened out there? An order was passed initially, an award of 19 lakh something was given with 9% from the date of institution of the proceedings. Very interesting. The amount, after 2 years, the appeal was filed. This court has condoned the delay.
Yes.
Appeal was admitted with direction of 50%. So they deposit 12 lakhs. Now, there was no, if you don't pass a specific order, then these 12 years has to be apportioned first towards the interest, then towards the cost, and then towards the principal. Thereby, as on the date on which this 12 lakhs was deposited, the total amount has already become 29 lakhs. So you deduct this 12 lakhs, so comes to 17 lakhs. But meaning thereby, the principal becomes 17 lakhs.
Yes.
There cannot be an interest on interest,
Yes.
but principal becomes 17 lakhs.
Right.
And with 9%, the amount goes very high. Now, what happened during the Lok Adalat? They said that there should not be any interest on 12 lakhs, which we have paid. Now, what the insurance did, they deducted the 12 lakhs originally from them,
Yes.
making it 7 lakhs, and interest was on 7 lakhs from there to till final amount disposal. They have made it 7 on interest was only on 7 lakhs.
Right.
But without taking into account that as on that date, when the order was passed, the amount of interest has already accumulated 12 lakhs.
I get your.
So the principal remains instant.
70.
So you can't deduct from there. So the principal, if it remains, the interest keeps on accumulating. So this, I had to make all these calculations.
That has taken the entire evening.
Huh?
That has taken the entire evening. Of like.
uh,